6, I learned from is appearing for the petitioner. Possibly it has to be taken up now for final disposal. Or I have been just handed over the file, so I'll need just sometime next Tuesday, my lord, I'll come prepare.
Item 6.
My lord.
Yes. Yes. 3. You are for the state.
My lord.
3D Mazumdar, learned AAG, submits that the brief has been handed over to him recently and he prays for some accommodation. Para. Also heard 3D Das, learned counsel for the petitioners. Para. On request, matter is adjourned to be listed on
28.
28. 7. 28.
Oblige.
May please, Your Lordship. I have a similar prayer in respect of item number 5, madam. 7, I'm sorry, madam. The pleadings are complete.
7.
Yes, I only needed some time, madam, to.
When do you want, Mr. Goswami?
On Friday.
This Friday.
On Friday, madam. Submit to my.
Whenever you say, we can have that. Friday also we can
Thursday,
have.
I have some other matter.
Friday we'll try. On a request made by Sri B.D. Goswami, learned counsel for the petitioners, matter is adjourned to be listed on 24.
Madam.
24/7. Sri B. Gogoi, learned AAG, is present for the state.
Much of it.
Yes, Mr. Thor.
So for item number 16 is concerned, Lordship.
Item number
16.
16. Yes.
They have compromised, private respondent as well as the petitioner has compromised, so I beg to withdraw.
Okay. Sri R. Dhar, learned counsel for the petitioner, has submitted that during the pendency of the writ petition, the matter has been amicably settled. Full stop. State, who is there? Also heard Sri Bokolia, learned state counsel. Para? In view of the aforesaid submission, writ petition is dismissed on withdrawal.
Oblige.
Compromised, and accordingly he prays for withdrawal of the matter. Upar, huh? Ligdon. Yes.
Lordship, I have a prayer for listing the petition tomorrow.
Motion matter. Motion by whom?
For the APGC. The APGC has filed.
APDCL has filed a writ petition. Against whom? Union of India.
Against the.
Ombudsman.
What for the labor court is there? The minimum wage.
What is the urgency in a labor court award?
The recovery proceedings.
We'll start. We'll have it on Friday.
Kindly possible.
No, it is possible, but there has to be an urgency. Recovery will not start within 1 day. 1 day, nothing is going to happen. Friday.
May I please?
Item number 19, madam.
19.
19, madam. Message Technico, madam. I appear for the respondents 1, 2, 3, 4, and 5, madam. I'm yet to file my affidavit in opposition, madam. I need some time. I've taken consent of my senior prime minister, Shiladitya, madam.
Okay. On the prayer of 3, M. Sharma, learned standing counsel, IOC. Matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Para? List on 3 weeks we are saying. 1, 2, 3. On 17th of August.
Office, madam. I'm ready.
Yes.
My lord, in regard to item 1, my lord, I just convey a message.
Infractuous.
No, my lord. Your lordship just can see the letter. In fact, they have received that letter yesterday.
Whatever is there in the court, you argue. Otherwise, we dispose of this matter. You tried your best.
So what I'm
If you don't want to represent you, that also liberty we will give it to you.
well, what
because-
I'm proposing, since I have given the letter yesterday, they have received it. Another 2 days time. In the meantime, if they do not do anything, my lord, I'll just leave it to you.
That order we are not passing now. Because we had made it very clear. On the last occasion, we were very reluctant to
Yes, sir.
grant time.
My lord,
We are not adjourning matters of 17.
My lord, then your lordship.
If you want, you can withdraw.
At 2 p.m., my lord.
If, as the last matter we can have.
All right. That will-
Because if the list gets exhausted, 2 p.m. may not, as the last matter.
Right.
Or at 2 or the last matter, whichever is earlier.
Yes. Obliged.
Okay.
May I please, your lordship? With the concern of the other side, I'd like to mention item number 9.
9, yes. Can you take back this letter, Mr. Junior Datta? Mr. Siddhanta, whoever is there. You don't go ahead, your episode, huh? Mr. Sayola, kindly hand it over to your senior colleague. Mr. Sharma is also there. Okay. Okay. Item number 9. What do you want, madam?
I seek short adjournment for, as my senior is, so I have some personal difficulty.
Okay, Mr. Sir.
Taken upon 28th.
2-8.
Yes, sir.
Okay. You have filed affidavit, madam?
Yes, lordship.
Okay. Your name, sorry.
Didas.
Didas. Ms. Didas appearing, Didas, Learned Council has made an adjournment on behalf of Sri S.P. Chaudhary, Learned Standing Council, NIT. Full stop. Also heard Sri M. Sahewala, Learned Council for the petitioner. Full stop. Para. The pleadings are complete. Para. List for admission hearing on 28/7. 28/7 would be next Tuesday. Next Tuesday, there are many matters fixed. We can have it on 30, on 37. Please tell. Interim order passed earlier to continue till the next date of listing.
May I please, your lordship? Lordship, with the consent of other side, lordship, I beg to mention item 12, 13 and 15, lordship.
12,
13 and 15, lordship.
13 and 15, yes.
So my senior has some difficulty today, lordship. That's why I'm bringing adjournment.
PWD,
PWD has also I have taken consent, lordship.
taken the consent.
Yes, lordship. And
Oh.
NRD also I have taken consent.
Okay. 12 also, Mr. 12 is different.
12 is same, but only colleague's name has been shown, our name has not been
Okay,
shown, but same
okay,
matter,
okay.
lordship.
Request for adjournment has been made on behalf of Sri S. Bhattakur, Learned Senior Counsel for the petitioners, yes, sir, in these cases. On personal grounds, para. Matters are accordingly adjourned to be listed on. We'll have to give a date.
14th August.
We'll have it on 27th of, not 27th, 27th to be seen on 31st of July,
Lordship.
31st of July, 31/7.
Can it be on August, lordship?
Hmm?
Can it be on August? First week, lordship.
Okay, then we have it on 5th of August. Is it
Lordship,
okay?
lordship.
5/8.
Obliged, lordship.
My lord, with the consent of the petitioner.
Mr. Sekil?
Lords. I beg to mention item number 11. I have informed the other side. Lordship, I am not very well today to go for a full length hearing.
Okay.
So if the other side does it, Lordship, let me reply day after tomorrow.
We'll have it day after tomorrow.
Lordship, keep it as item.
Friday we can have.
I have no difficulty
Yes,
except I am.
Friday is
to a
better
long
than the
hearing,
other.
Lordship.
Day after tomorrow is Friday only,
But
No, Thursday.
or Thursday.
Thursday.
Thursday we'll have,
Lordship, Thursday, you may have to accommodate me.
Then Friday.
Friday is better.
Friday.
I am ready
But
to-
Lordship,
Friday.
I
Friday?
can't oppose to somebody not being well
No,
and therefore an
Friday we'll
adjournment.
have.
But
Hmm.
we've 1 year of 2 years has gone by, so there is
That's
an
okay,
urgency.
that's okay. Some personal
Yes. I can't
inconvenience
oppose to
we
that at all.
accommodate
But
normally.
Friday should be it.
Okay.
Let it be Thursday, Lordship. That will be convenient because this will consume a lengthy.
Thursday we can accommodate. You have a difficulty on
We have
Thursday.
Another hearing, so.
Doesn't
if-
matter, we'll
we will have to
accommodate you,
accommodate.
but-
Lordship,
but
keep it on
we'll-
Thursday, and if
we'll-
it doesn't happen, then Friday.
Otherwise, Friday, others will suffer.
Okay. Other will not suffer.
Friday because it is a lengthy
No,
hearing.
no. Lengthy hearing we'll have it after the motions.
Lords, I'll leave it to do some. I'm
Fri-
available both days, Lords.
Friday we'll have it as the first full length matter.
Lord.
We'll have it.
Or Lordship, we keep it on Thursday and if need be, pass over and
Okay then Thursday. On a request made by Sri D. Sekal and Senior Counsel appearing for the Oil India Limited, matter is adjourned to be listed on Thursday.
Deeply obliged, Lord.
Please remind this court that if required, we will accommodate and have it on a priority basis.
Obliged, your Lordship.
Okay.
Obliged.
Miss Irulekha, G. Goswami Learned Senior Counsel is present for the petition. Yes.
With the consent of the petitioner, I beg to mention item number 3 and 4.
3 and 4.
Senior is not.
3 and 4.
Senior,
Hmm?
he's absent today, he's not well.
You're for the FCI. You're seeking time. Yes, you're for the other side. When can we have this?
27, Lordship.
Tomorrow or day after tomorrow.
Lordship 27. Can we fix the 27, Lordship?
27th.
27.
27 July.
27 July.
27th is okay for you? Okay. A request has been made on behalf of Sri B.K. Singh, Learned Standing Council FCI for adjournment. Para? In view of the above, matter is adjourned to be listed on 27 July. 27/7. Item 1 order and 3 and 4 connected.
Obliged, Lordship.
Is there any interim order?
No.
Yes.
Please, Lordship. Lordship, I beg to mention a matter for withdrawal for tomorrow. Lordship.
Mate, please, your lordship. It's not before lordships. My lord, pursuant to NIT dated 3/1/2026 in respect of Lalsara ferry service, my lord, petitioner submitted his tender, my lord, as a highest bidder, my lord. He offering the bid value of rupees 18,66,000, my lord.
You are found to be the highest bidder.
The highest bidder, my lord. And respondent number 8 offering 13,13,131, my lord.
Hmm.
My lord, as a new tender, my lord, we have no any experience certificate, my lord. And there is a clause 12C of the NIT, my lord. Your lordship go to pay annexure to page 26, my lord.
Page 26.
Page 26. This is the 25. Is a detailed terms and condition of the NIT for lease of the ferry service, my lord, and turn into page 26, my lord. Serial number 12, my lord. 12A, B, copies of the experience certificate ferry business issued by DC, ADC, SDO must be submitted along with tender. C, my lord. I am concerned with C.
C, yes.
Yes, my lord. In case of new tender, a certificate about financial soundness of the tender from the DC, ADC, SDO, Sodor, SDO Civil of the district subdivision, or any nationalized bank should be enclosed, my lord. As a new tender, my lord, I am submitted the nationalized bank, my lord, for my lord, soundness certificate, my lord. And my lord, thereafter, my lord, the tendering committee, my lord, by the minutes of the tender committee, which I challenge before lordships, page 42 annexure 10, my lord. And turn into page 44 in respect of our, my lord, ferry service, my lord. Page 44, serial number 8.
42 is the minute.
42 is the minutes, my
Date
lord.
of the 19th.
On 19/6/2026, my lord. Office chamber, the managing director.
Okay.
AIW.
Where is your discussion?
Yes, my lord, page 44, my lord.
44.
My lord, serial number 8.
Lalachera.
Lalachera ferry service. May I read, my lord? As per comparative statement, it was found 5 bidders have participated in the tendering process for settlement of Lalachera ferry service for so. All the bidders have deposited their required amounts, earnest money, along with tender. The estimated so-and-so, name of the bidder. My name is serial number 1. This Sahib Ali failed to submit experience certificate. All other documents submitted as per NIT. And serial number 2 is the respondent number 8. Is offering lowest bid, my lord. All documents submitted as per NIT, my lord, which I challenge before lordship. As a new tender, I have no any experience, my lord. There is a clause in the NIT that if there is no any experience new tender, they have to submit. And in my lord, certificate issued by the page 41. This was submitted by the Punjab National Bank, page 41 annexure 9, but which was not considered because of that there is a no any experience certificate. This is my main, my lord. And thereafter, my lord, page 46, the Director Inland Water Transport, my lord, temporarily directed to operate to the respond number 8, page 47, my lord, which is challenged before lordship, my lord. If we go to the rules also, my lord,
Yes,
there's the amendment rules, my lord.
please read it. We have it. We have it.
Yes, yesterday I have flag mark lordship.
There's the rules, my lord,
Already
amendment
flag
rules.
mark. Homework done, madam.
Yesterday only.
There's the amendment by notification 18 May
Yes,
76,
which,
my lord.
which?
My lord, para rule 16.
Yes.
IF, my lord. There is a clause. In case of a new tender, in addition to the above documents, a certificate about the financial soundness of the tender from the Deputy Commissioner, Additional Deputy Commissioner, so and so, as the case may be, officer, as may be,
Tenderer.
or any nationalized bank should be enclosed, my lord.
Yes.
I am the highest, my lord, bidder, my lord. My highest bid was not considered by the authority. Only on the basis of that, my lord, I have no any experience certificate. As a new tender, my lord, I have necessarily I have no any experience, my lord. Your lordship got it, my lord.
Mr. Bora, there would be a requirement of application of mine with the meaning of expression new tenderer.
New tender,
New tenderer doesn't mean that you may not have experience.
my lord.
New tenderer is a tenderer who's for the first time put his bid in a process where his financial soundness is required to be authenticated by a bank.
Bank,
If, unless you say, you make out a case
my
that
lord,
C has been incorporated only to overcome B, then you may have a case.
my lord.
Suppose in 12B, there is a requirement of experience certificate for ferry service.
My lord,
Okay? And C says, in case of new tenderer,
my lord.
you have to make out a case that C is for a person who cannot meet the requirement of experience
My
certificate.
lord. This is my case.
That is your case.
My-
But if the interpretation is not correct or other experience certificate is a mandatory requirement, then whether it's C is there or not will not help you.
My contention is that I am the highest bidder.
Highest
my lord.
bidder has to be a valid highest bidder.
The highest
There
bidder.
is no
But my
ambiguity with this proposition of law.
My lord,
Highest bidder means valid highest bidder.
My lord,
Who is a valid highest bidder who meets all the requirements?
my lord,
Now, there is a requirement to have an experience certificate.
my lord,
You were contending that there is also a clause
my
for a
lord,
new tenderer so far as financial soundness is concerned.
my lord.
Now, this new tender, whether it will overcome the requirement of 12B, which mandates an experience certificate.
My lord. My lord, my contention is that, my lord, is since, my lord, I have submitted, my lord, by the bank financial soundness certificate.
Now, whether that will overcome, that will meet the requirement of not being an experience, not having an experience certificate.
And if all also go to the page 28, annexure T, there is a, my lord,
Madam, regarding any other tenderer, how do you assess the financial soundness?
Yes, before that lordship is
Hmm.
holding the rules, my lord. Yes, then lordship may kindly have a look, rule 19.
19,
Yeah, I have like my pink flag, I think.
19, yes,
Here it, my lord.
yes.
Rule 19, the sale by auction tender shall generally to be the highest bidder tenderer. The officer conducting the sale calling for tenderer, however, refuse to accept the bid tender. If any of the requirement of the bid tender is not satisfied or the sufficient reason to be recorded in writing underneath the hand in the so the 19.5% may directly go 19.5. Whether the tenderer bidder has sufficient experience to run the ferry service efficiently. This is the condition, mandatory condition for ferry service to run the IWP ferry service matter. Here, lordship, the new tenderer means new tender to the IWP ferry service only. He may run the ferry service under the panchayat department, under the local authorities, but new does not mean he is the fresh tenderer. So that clause that my senior has referred, my lord, 12B and C, it is not or, it is and. Lordship, may kindly have a look the NIT condition, page 26.
Yes, we have seen it.
Yes, ma'am. The conditions is given in the NIT condition 12B, my lord. Copies of experience certificate of ferry business issued by the DC, ADC, SDO, such and such must be submitted along with the tender. C, in case of the new tenderer, here new means new to the IWT ferry services. New tenderer, a certificate of about the financial soundness certificate, such and such should be deposited.
Madam, so far as a tenderer who is experienced,
Lordship.
how do you assess his or her financial soundness? What is he required to give?
He's also have to deposit the bank statement or
No, why have you-
income tax file return.
No, where have you stated?
ITA. No, 12A.
12A
Yes, ma'am.
must be submitted along with the tenderer. Have you made clear? Okay. So for a new tenderer, you need an additional financial soundness.
Additional requirement.
Otherwise, for an existing tenderer who has participated earlier, his IT returns would be sufficient for. Okay.
In fact, Lordship, 16, rule 16 that my learned senior is referred,
Yes. Amended.
amended.
Yes.
16, he has read the rule F in
Mm.
case of new tenderer.
Mm.
D, Lordship, may kindly have a look. C,
Mm.
certificate of experience of ferry business from the deputy commissioner,
Okay.
additional deputy commissioner. so that-
We'll consider
My
this.
lord,
You have raised a new point.
my lord, there's a new tender, if new tender.
Let us consider, we'll consider.
They will not, my lord, any chance, my lord. Why they are putting
If
the
the
new
petition-
tender, my lord?
He queries, he could have
No, no.
approached the department. before.
Mr. Bora,
My lord.
you're raising a very significant point.
My lord,
But in that case, you have to put to challenge the requirement of experience.
my lord. But experience is.
Your point is very valid that a new person will never be,
Never been, my lord, necessarily, my lord.
never be able to participate in any such.
Such. And if I am
So
the.
you introduce some mechanism whereby in lieu of experience,
My lord.
you can have some other accessibility test, but those I have to make a separate challenge.
My lord. But my.
Here we'll examine, let us see
My humble
whether the other request C is an alternative to B. That is the point you are raising, isn't it?
And my lord, tender from also it is specifically, my lord, mentioned, my lord,
Hmm.
is page 28, my lord.
2.8.
Yes, my lord. First, my lord, four land documents, all are given up-to-date income tax, all are 6. Expense certificate, business issued by so-and-so. So in case of new tender, financial soundness are issued by the, why they are putting that? One, same serial number
Page
6,
20.
28. They putting the tender notice, tender paper, my your lordship, my lord. 6, serial number 6. X, your lordship got it, my lord. Serial number 6. Experience certificate in ferry business issued by DC, ADC, so-and-so. In case of new tender, financial soundness certificate issued by the DC, ADC or the any national bank, my lord. That means my humble understanding is that, my lord,
No, that-
alternative, my lord.
Oh.
Your lordship
Okay, heard. Sri N. Bora, learned counsel for the petitioner who has put to Mr. Sharma for whom?
Respond number 8.
We'll examine and we'll hear you later, not on record. Let's put to challenge our settlement process, our settlement of the Lala Chera ferry service with the respond number 8 pursuant to an NIT dated 3/1/2026. Full stop. It is the case of the petitioner that he is a new tenderer and the NIT itself provides
Page
that
26.
new tenderer would also be accommodated provided a certificate about financial soundness is submitted by certain authorities. Full stop. It is submitted that the petitioner had met such requirement as incorporated in clause 12 within bracket C of the NIT and was adjudged and his bid was found to be the highest. Full stop. However, wide the impugned minutes of meeting dated 19/6/2026, the bid of the petitioner has been rejected on the ground of not having an experience certificate and subsequently vide an order dated 4/7/2026, temporary settlement has been given to the respondent number 8. Full stop. Para. We bother the learned counsel for the petitioner has also placed before this court the Control and Management of Ferry Rules 1968 and the amendment made and the as a within bracket as amended. Full stop. He has submitted that there is a statutory requirement in Rule 6
16.
in Rule 16F. 16F, is it 16F?
Yes.
16F for submitting financial soundness by a new tenderer. Full stop. He has submitted that the petitioner having met with such requirements, his bid could not have been rejected, more so when the amount offered by the petitioner is higher than the amount of the respondent number 8. Para. Per contra, Ms. M.D. Bora, the learned standing counsel, IWT, has submitted that the petition has been instituted on a wrong presumption. Full stop. She has submitted that the requirements under clause 12B and 12C are not in alternation, are not alternative, but both are required. Full stop. She has submitted that it is not in dispute that the petitioner is a new tenderer, and therefore, as an additional ground, financial soundness certificate from certain authorities are required apart from the IT returns, which are meant for our existing tenderers. Full stop. She has submitted that there is a difference between a new tenderer and a fresh tenderer. Full stop. She has submitted that in any case, the requirement of experience cannot be done away with when such requirement is statutory in nature, apart from being stated categorically in the tender notice. Para.
Rules 19.
Okay. She has also referred to Rule 19 within bracket 5, small 5, which where the requirement of experience has been specifically stated. Para.
From my page 26 in tender from my.
Rejoining his submission, the learned counsel for the petitioner has submitted that even in the tender form,
Page 28.
both the condition regarding experience and for giving a financial soundness certificate by a new tenderer has been put together in serial number 6. Para. Let notice be issued. The matter would may require certain deliberation. Para. Let notice be issued. Returnable on we'll have it on 17th of August. Is it okay? 17th of August. Ms. Bora, the understanding counsel, accepts notice
1 to 6.
on behalf of respondent number 1,
1 to 3.
TO 26, District Commissioner, Sri Bukolia Learned State Council 7, Mr. Sharma 4, and who's for 9?
No,
Now, why have you made 9 party?
No, my lord, it is.
Okay, 8, Sri A. Sharma, Learned Council has entered appearance for respondent number 8. Extra copies. Let's tell for service of notice upon the respondent number 9 be taken by split AD. Para. Let the returns be filed. Let the response be filed before the returnable date, and an endeavor will be made to dispose of the matter at the admission stage.
So big deal, lordship.
Till then, my lord,
No, lordship, it's a public ferry service.
this is my submission, my lord.
This is the life of public. Lord.
I-
Deeply obliged.
This is my submission, my lord.
In
My
flood,
lord,
how can you run a ferry? Everything has been washed away. Not in Silchar, perhaps.
My lord, Haila can define.
It's Hailakandi, okay. Lala Chera, okay.
Till then, my lord, stay, my lord.
Difficult. Well, therefore we had made the observation.
Yes, yes.
We'll try to dispose of on the returnable. Much. 20?
That forest.
Yes, yes,
You just-
yes. Any instructions, Mr. Govind?
Separately chart from the green melons. There were two petitions. One is P739. And another one is P645.
Hmm.
But no action has been initiated against them.
Is it?
3-7?
P739,
Motizuddin.
Mofizuddin,
Mm,
and
Mof-
People Islam minors. Nothing against them. No seizure.
But it is sealed by the seal. So far, the.
Record his statement.
In fact, it has come with instructions.
But
Written
record his
instructions.
statement.
I am out of my business, my lord. It is sealed, my lord.
Okay.
Sealed, not seized. Just sealed, my lord.
If there is any sealing, then you remove the seal.
It has come with the instructions.
But we made a special statement also, my lord. Yeah.
Otherwise, why should he come running to the
Yes.
court?
But written instructions.
This is only sealed, my lord, not seized. Then Hafiqul Islam.
And Mofizuddin.
Why do you find a very young lady in the court?
My lord?
Huh?
Oh, yes.
Why is she in the court?
Because her husband is out of Gauhati, my lord.
Doesn't matter. You can live with her, some of your colleagues. Why should a tender child be in the court? Unless she enjoys the proceedings. And I don't think there is anything to enjoy in the proceeding in the High Court.
She only can sing.
Huh? Ask her to watch the TV or something or some games. In the old building, we have a crèche also. She can be there. Don't bring her to serious matters. Yes.
Yes.
Smile, kindly peruse the instructions. At the bottom. These two are mentioned from. Please,
Which page? Which page?
Page 3.
Page 3. Page 3 is the last page.
My page instructions,
Instructions we are having.
just before the signature of the DFO,
Yes.
just about it, that mentioned.
Both establishments continue to remain entirely unaffected. Jan Furniture, Rafiqul,
Yes.
and Hawk Furniture, Mufizuddin.
Yes.
And their claims and seizure are fabricated. Well, take instructions.
My lord, why should we come here if it is not sealed or not that thing? It is of a specific point, my lord. This so far this item number 23 and 24. 23, my lord, only sealed, not seized. And 24, my lord, you already sealed on 6, 7.
When did you take the last instructions? Yes, who's with you, Mr. Ahmed?
I'm the 26 million.
No. In these two matters, can you take instructions?
I can take one.
Huh? Please have the instructions.
Mine.
For these two, we'll have it after a while. Let the others we examine.
Hmm?
Specific statement to the.
We made a special statement, my lord.
That is what now, what in view of what
Yes.
Mr. Gogoi is
My
submitting,
lord.
let him take the instruction.
Whatever he got, my lord, we have nothing.
No, let him have the
Yes,
telephonic
yes, ma'am.
instruction. Let's go out and have a telephonic instructions.
So, forget to do that.
That part of the other three matters.
Yes.
Last occasion I had submitted that over phone, I had got some instruction that notice was the issue. But exactly, I don't find the last.
But
page.
your notice was for registration.
Registration, my lord.
But if you do not register,
They cannot open,
Generally-
they cannot open the shop.
Generally-
They are dealing with timber, they are dealing with forest.
but they
produce.
have, okay, they are dealing with forest.
Forest produce. my lord.
Unlike any other business,
Yes,
they
yes.
require a registration.
Madam.
But what violation we have made, they did not spend. Again, we have-
Registration is under which provision of law?
My lord, this the lodgeable fine, it's annexed with the WBC 3648 Hussain Furniture. We have brought in a set of
36?
new rules, my lord.
Oh,
This is my lord's Hussain Furniture.
Yes, Hussein, we have got.
Lordship will kindly come to page 28 therein, my lords.
28.
These are rules of 2023.
Page 28.
28.
Yes.
Food based.
Okay.
Food based or settled.
Assam food-based industries establishment and regulation rules.
Yes.
These rules are made in my lord, under the provision of some forest regulations, my lord. Regulation subsection 2 of section 14. And There is my lord specific, earlier than that, my lord, there were some rules of 2000. They were also repealed, my lord. These now occupy the field. There is, my lord, that lordship will find that communication, we have found them in violation of rule 8, my lords.
Of this 2022 rules,
Yes, my lord, rule 8.
Rule 8.
Yes. Rule 8, lordship will find that. 40, no? Lordship will find it, page 46.
Rule 8. Yes, please.
Rule 8. Which you will see they have to be registered, my lords. There's a committee, my lords, registration committee, since they deal with forest produce. Basically, my lord, we are on the source from where they are sourcing the timber.
Registration with whom?
Well, there's a committee. Registration committee is there, my lord. So we'll find it that sub 8A sub 4. There is a committee, my lord, mandated under these rules. The committee will do the needful. One has to apply, my lords. He has to apply within with a form. Online, my lords, they have to apply. Everything is online, my lords. So then they have to pay some fee also.
Just a minute. What is the consequence of non-registration?
Non-registration will lead to, my lord, penalties under the will fall back to, my lord, 49. 49 of Assam Forest Regulations. 49 confiscation proceedings, my lord. Because the rules are made under that Assam Forest Regulation. So violation of this rule will fall back to, my lord, 49(1).
Okay. You have not registered.
They have not registered.
It is with municipality.
No, no, not municipality.
Yeah.
With this committee. Committee has been defined under 8A4.
No, that is they have applied as a union form.
Applied.
Hmm?
After they having the general notice.
Yes.
After general, they have applied my online payment, the annexure is there.
Where is
They applied.
where are the documents?
Page 112,
Yes.
little date.
At phase 1.
112 date is very pertinent.
Yeah.
102,
112.
112
112, 22/6.
minus.
And when did you take the action?
That's,
35, 2026.
35.
30.
305, 2026.
That's all.
After the action has been taken. Okay, now let us assume they have violated the requirement of registration and they were negligent for applying on time.
Minus.
But nonetheless, once you had directed sealing, they had moved on 22/6/2026. You can still consider,
Still you can consider. Minus.
you come up, give them the outcome. If you find that they have made the requirement, after all verification, you do this within a time-bound frame. But yes, you may be correct in contending. Without registration, you may not be allowed to operate.
Minus.
But their main contention was this selling was done without any notice.
Yes.
That is one part. We have to see where notice was given. Where is the notice? Any instructions?
Instruction space minus. That
Yes. Normally, how long do you take for a verification exercise pertaining to registration? Is there any time frame? See, we have seen, so we have seen that the requirement of registration differs from the nature of the wood-based industry. There are various other registration committees for agar-based, for timber-based. There are 3-4 committees we have noticed in the new amended rules. Now, his comes under section 8 as pointed out by you. And it also transpires that on 22/6/2026, they have applied. So you consider pendency shall not be a bar for considering passing final orders.
that we will do. But only issue which now comes up, Malad, does it will that consideration regularize those past which we have already seized, Malad?
No, there are two issues. One is seizure, one is sealing. Seizure and sealing are two different aspects. Sealing means complete stall of the business. And seizure is whatever is seized, whether those will be held in your favor or their favor, we do not know as on now.
Exactly.
But sealing means they are not being able to do the business totally. You conclude this exercise in a time-bound manner and pass orders.
Fine.
Mr.
Madam, we got the information, the other one, it is sealed. Man.
Sealed.
Yes, man.
How?
Maybe, Malad, two authorities are involved here. Malad. Municipality is also there, forest is also there. Kuwadi forest, Malad, we have no issues regarding those two shops, Malad.
Mr. Chaudhary, we do not have any reasons to disbelieve the written.
No, I'm not saying, madam.
No, not him, written
Whatever he's
instructions.
saying is on the instruction, but instruction is
Not
wrong, man.
believing a council, that is out of the
Right.
question. We believe all councils.
Notice. In the notice, they have stated my violation of.
But we also believe the written instructions.
Yeah.
Nobody will give a written instruction in the court. There may be some other obstructions. You have to
No, let
inquire.
me say, madam, what violation, what is the
Now,
violation?
they have said that there is no sealing.
If you,
Amar to issue forest.
From their part, there is no problem.
yes. So.
You have to inquire. There may be some other issues
Other
like
side, the municipal board, my lord.
is the party,
Yes,
municipal the
municipal
party.
party, but they are the person, my lord. They are saying that we have violated the municipal act and rules.
Yes, municipal. Municipal takes notice. Who takes notice? Government advocate. ठीक है जुली. Board, I think a notice will have to go.
Municipality, we have already served the copy on the other day also.
No,
Both, my lord.
Huh?
But as a result, madam, we are getting nothing. Everything is sealed, my lord.
No, it is in the motion stage.
Yes.
Municipal board are not represented by the state council.
Yes, madam.
So you need to,
You wanna say?
can you serve dusty upon the,
Yes, madam.
we can issue notice.
Yeah.
We can record the submission of Mr. Gogoi in all the cases, including these two cases of Hafiz and Mufiz and Rafiqul.
Yeah.
And so far as the other aspect is concerned that you have applied, we'll ask them to, forest authorities to complete the process expeditiously. What is the normal tenure? Grant?
25 days, madam.
25 days, very good.
Madam.
They have already applied on 35.
Yes.
Oh, more than 25 days, no, not 35, 20, 20 to 6,
Hmm.
almost a month.
Yes.
You come on
one
the-
aspect, madam, that which is disturbing us, madam, because if this regular registration is, if say it is in your favor,
Hmm.
madam, will it, madam, and will it release those, will it, madam, regularize their past misconduct, madam?
Mr. Gogoi, you have not even gone, explored to that area.
Madam.
You do not worry about those areas. We'll discuss.
Nobody will take it.
We'll discuss whether retrospective regulation is possible.
Madam.
That has not even come up for consideration. We'll discuss.
Madam.
Okay.
Because we contemplate, we are issuing a confiscation process.
That will be subject to their liberty to.
No, that is also important. That we have made a statement, my lord, that it to be stayed. Because without any ground, madam, nothing at all, my lord. Now he is saying violation of forest law. And they have stated violation of municipal action rules. What is the, we are going again and again, nobody is responding. We say that there is order from high authority, it is to be sealed.
High authority means?
I don't know. Just say.
Subject to petition.
It is, my lord, about 100 shops, my lord, only pick and choose, my lord, 25 or so, said, my.
High authority means many.
I
there
don't
will
know,
be-
my lord, that is, I
There
cannot
will be
say.
many
I
interpretations. High
cannot- yes, my
authority.
lord. Your lordship may interpret the way, how your lordship understand, my lord. I cannot say.
We don't understand. You'll have to make us understand. What is the meaning of high
No
authority?
problem. Now, these two shops, they are saying it is not sale. Till today, madam, just now he got the information. Sale.
Okay,
So about these 2 year lordship may make some observation, madam.
okay.
We may be allowed to continue. Madam.
If there is no, provided there is
No,
no,
not they said
provided.
it's sale, madam.
No,
Not
we,
sale.
no, we will record his submission along with his
So
written instructions that so far.
then your lordship may kindly make an observation, my lord, because if there is no sale, nothing at all, that should be allowed to continue, my lord.
Unless municipal board
Yes.
comes up with something, we'll make that observation. Heard. Sri H.R.A. Chaudhary, London Senior Counsel, assisted by Sri, your name?
SS Ahmed, madam.
S.S. Ahmed, as assisted by Sri A.M. Ahmed as well as by Sri S.S. Ahmed. For the, you are appearing for all the
Yes, yes,
all for the
yes.
petitioners. Full stop. The petitioners are aggrieved by, amongst others, actions of sealing, SEALING, of showroom, manufacturing unit, godown, which are connected with timber business. Full stop. It is contended by the London Senior Counsel that the petitioners have trade license and are following all the requirements of law and running their respective business. Full stop. It is also contended that such sealing has been done without any prior notice. Full stop. Para? When these matters had come up for consideration on the previous occasion, this court had directed Sri Gogoi, D. Gogoi, learned Planning Council Forest Department to obtain the instructions. Full stop. Para. Sri Gogoi, the Learned Standing Council has submitted that written instructions dated
27.
2026 have been obtained. Full stop. At the outset, he has submitted that so far as the petitioners in WPC 3645 of 2026 within bracket Rafiqul Islam bracket close and 3739 of 2026 within bracket Mufizuddin bracket close are concerned, there is no action taken by the Forest Department and therefore there may not be any existing grievance. Full stop. Para. It is, however, required to record the immediate response of the learned senior counsel, who upon instructions has submitted that the establishment of the said two petitioners still continue to be under seal. Full stop. Para. So far as the other writ petitions are concerned, comma, the learned standing counsel has drawn the attention of this court to the Assam wood-based industries within bracket promotion and development bracket close rules 2022, which amongst others mandates a requirement of getting the unit registered under a registration committee. Full stop. Specific reference has been made to Rule 8 of the said rules, comma, more particularly Rule 8, capital A, within bracket 4, which also defines the registration committee under which such registration is required. Full stop. He has submitted that in spite of repeated notices to the units to get those registered, comma, no registration was done, leading to the impugned action on 30/5/2026. Full stop. He has accordingly justified the action. Full stop. Para. The learned senior counsel for the petitioners has, however, submitted that pursuant to the impugned action, comma, applications have been made by the respective petitioners for getting the units registered, and the rules prescribe a period of 25 days to complete such process of registration. Full stop. Mr. Chaudhary, all have applied on 2026.
No. No, Kumar,
My application is 22nd/6/2026.
That we have said 2026. Others?
Others, some of them apply, some of them not. Because they did not get any notice, my lord.
Okay, okay.
A general notice was issued.
Plaster to all bodla bolebo. Plaster to bodla bolebo. Ki asile?
Sorry.
Taragot to. Person to? Some of the petitioners.
Yes.
One
Furnitures apply.
also one of the petitioner has applied for such registration. Full stop. Para.
Another aspect he said, madam, the notice, written notice given, not a single notice, madam. That you must.
Okay. Full stop. He has reiterated that no notice was issued before the sealing. Para. The issue would require some deliberation. Para. Let notice be issued, returnable on, we give a short date. Today is 20, no, 21.
21.
Can we have it on 4th of August? 4th of August, 2026. Who will take Mr. Bokolial for Chief Secretary?
Municipal board.
Chief Secretary particular.
All the respondents are in the same pattern. Mr. Ahmed? Respondents are not in the same pattern.
No.
So how do,
Forest and municipality, madam.
Mainly forest.
Forest and municipality.
no, while issuing notice, how do you? Sri G. Bokolial, then the State Council accepts notice on behalf of the state authorities, whereas Sri D. Gogoi, then Standing Council Forest, accepts notice on behalf of the Forest Department and its officers. Full stop. Let steps be taken for service of notice by speed posted AD with speed posted upon the other respondents, including the municipalities.
The municipalities, what is made by, they casually municipal.
No, since we are passing one order,
Yes.
we are making a general kind of, you take steps accordingly, okay? Upon the municipality, steps within 2 days. Full stop. So far as the petitioners in WPC 3645 2026 and 3739 2026 are concerned, comma, since the Forest Department has in its written instructions categorically stated that there is no action taken by the Forest Department, comma, the petitioners be allowed to run their business unless there is any other legal bar which has to be indicated by the next date, full stop. So far as the other cases are concerned, comma, if applications for registration have been filed or would be filed, comma, those are required to be considered in accordance with law without being influenced by the fact of the present challenge being instituted in this writ petition. Since the business of the petitioners are presently under seal, comma, this court would consider the option of taking up the writ petitions for final disposal at the admission stage.
My lord, about justice service in municipality, you may be allowed to also, my lord.
Justice, okay.
No, justice service.
উপরতে লিখিবা, huh? So far as the municipality is concerned, comma, dusty service is also permitted, which however is required to be routed through the registry of this court, and in the notice accompanying the dusty, comma, the next date is to be specifically reflected. The petitioners are also required to file affidavit
Yes.
in proof of such dusty service before the next date.
Obliged to.
The last written instructions is kept with the records. Both Mr. Ahmed, try to check who are the respondents for whom you need to take these steps.
Yes.
We have not specified the name, numbers,
Yes.
so you need to coordinate with the office.
In this matter, only 1 week time is required to, we have sent the affidavit for getting back not received back, my lord.
19 matter, why should we grant you time?
My lord, 2 days only.
Okay, heard Dr. A. Todi, learned counsel for the petitioner, para. 3. G. Bokolia, learned state counsel, has submitted that the affidavit has been sent for vetting and would be filed within a couple of days, para. In view of the aforesaid submission, as an exceptional circumstance, comma, further adjournment is granted to enable filing of the affidavit, full stop. List this matter on 29th. Today's no, not 29th, on 27th. Next Monday.
Much obliged.
Identify.
Yes.
It is possible for the time being, my lord. Mr. R. Sharma is just on legs in another court.
Okay. Mr. Gogoi, he has come.
Oh.
My lord, this matter, K. Gogoi will appear for time being, my lord. He is engaged in.
Oh, D. Gogoi.
K. Gogoi.
K. Gogoi, Kaustubh Gogoi. Okay.
Apart from that.
After a while, Mr. Sharma, what was the issue?
Issue is that a labor officer has passed an order. There was a complaint by one of the contractual employee. He's not an employee as such, that he has not received a Mazetia wage board wages. So there was a complaint. We had disputed the claim. Then he has decided on his own. As for the act as well as the Supreme Court order, he cannot. He has to refer it to the government for a reference. He has decided without discussing any evidence, anything on his own that we are liable to pay the Mazetia. So that order is without jurisdiction. He ought to have, once we have raised a dispute, he ought to have referred it to the government of Assam for framing reference. So that is a So your lordship can set aside the order and send it back for reconsideration, giving us opportunity to again.
Let him come, Mr.
Let him
Gogoi.
come.
And Mr. T Gogoi, you are for whom? Who's for?
The complainant.
Complainant. Okay. If the conciliation officer is of the view that there is a dispute which exists, he can make a reference. See, no, there are two proceedings. One is the proceeding before the labor commissioner to decide, and one is the raising of a dispute before the conciliation officer to make an appropriate reference. We need to first understand what is this kind of dispute. Is it a dispute which will be adjudicated by the, oh, this order is by whom?
By the labor officer.
Labor officer.
Mm.
Designation? Labor officer.
His labor officer, Dhamaji. In fact, even Dhamaji labor officer doesn't have jurisdiction. It is the
Labor officer, can he decide?
Lordship, my representation was submitted to Labor Commissioner Gauhati. Then it was forwarded to Assistant Labor Commissioner Dhamaji.
Now, can he decide? Or is he required to make a reference? Okay, let us see.
That
And,
also he cannot.
okay.
Because there's the act,
Yes, let him come.
the act and the Supreme Court clarifies that.
It is a tea factory, my lord. It has been registered under the Provident Fund Act, my lord. Assam, my lord. They have not registered it, my lord, although we have applied. 25/11/24 we have applied. And
Yes.
as per them also, my lord, we have started the factory, my lord.
My lord, after they applied to us for registration, our respective went there. And what they found is nothing is clear about the petition. First, your lordship may kindly take up page 19 of their petition. Page 19.
What is your grievance, Mr. Sayawala?
My lord, we have a tea factory, we have purchased a tea factory, my lord. Then, my lord, initially we have given it on lease, my lord.
Okay.
So now since 23, my lord, we have started the factory of our own. So
You
under
have you have done manufacturing on your own,
Yes.
not on lease
no.
now.
Now
Okay.
we have engaged, my lord, employees also. So under the, my lord, Act, my lord, Assam Act, my lord, they have to register it, my lord, because Provident Fund, my lord, the employees want, my lord, Provident Fund.
They are not registering.
No, 50% we pay, 50% from theirs, my lord. Then they get more, my lord. So we have to pay 50%, my lord.
Now, what is your difficulty in registering?
The first of all, we must page 19,
90?
page
119.
page 19 of their writ petition.
Okay.
So this is a sale deed after taking the due permission from the revenue. The Ketala Tea Company, it was the factory was under the Ketala Tea Company. It's within the garden. So here, if your lordship sees Messrs. Farmex Tea Company, bracket formerly Ketala Tea Company, down below, represented by Mr. Hatimal Pincha. They are selling it to an entity called Sopanam, that is in page 21. They're selling it off to an entity called Sopanam Enterprises Private Limited.
The petitioner.
The petitioner. They're selling it. Now, if your lordship comes to our affidavit in opposition, first, page 66 of our affidavit.
Page 66.
66.
What is this?
Now, page 66 is the report given by the control officer to the secretary cum PF commissioner, saying the problem, what is the problem in registering. First of all, my lord, when the fund manager went to visit the tea factory, what he could find out from their manager that this tea factory was closed, was shut from 2003 to December 2012. Now, in between,
Yes.
in the year 2013 to 2022, they had leased it to McLeod Russell.
Yes.
When McLeod Russell was running this teak factory, there were 456 workers which were used in the factory,
Yes.
and out of which only 10 employees were registered as members of the PF. Now they have given a list of 26 workers. Now, your lordship may kindly come to page 67. The year is very important.
Page 67.
67. Now, 67 is of 14th of November 2012. Here, the petitioner, that is Sopanam, is leasing it out to McLeod Russell.
Yes.
Now, your lordship will come in page 71.
Yes.
Page 71, here it says registration, Ketla Tea Factory. That is not relevant. 3, who is the occupier, under whose name it is? It is Mrs. Chanda Devi Pincha.
Page?
Page 71. Serial number 3.
Page factory license registration number. Occupier.
Occupier. Who is the occupier, under whose name it is? 1, Mrs. Chanda Devi Pincha. Then, your lordship will come to page 73.
Yes.
Page 73. Now, one Messrs. Plentex Food Private Limited, who says that now they are the owner, is leasing it out again in 2017 to McLeod Russell.
No, Plantex was earlier known as Sopanam.
Yes. Now here what they say, who is representing? He is saying that one Naman Pincha is the owner. Earlier, one Nirmal Pincha is the owner. Now our thing is that we will register, but please give us all the documents. Come clean, give us all the documents. And what happened to the laborers who were working in between? Give us all the documents, we'll register. Under these circumstances, we cannot register. And the list of 26 workers that they are giving is of 2025. Page 72. So what happened earlier? In between, who were the workers? So if they come up with all the documents giving it to us, definitely we will register. Why not? But under these circumstances, how can we register? Nothing is clear. Everything is ambiguous, my lord. First, and now they are giving it saying that Plentex is the owner, 2017. Now the petition is Sopana. Nothing is clear.
When was the change of name from Sopanam to Plantex, Mr. Sahiwala? Now again, see, this was of 17 at page 73.
Yes.
So if Sopanam has been renamed, rechristened as Plantex, the present petition is in the name of Sopanam again. When did it go back? Have you filed your rejoinder, Mr. Sahiwala?
No, madam.
You file your rejoinder, explain your position. You may have some explanation which are acceptable.
Yes.
We'll consider those, okay? Third, Sri G. N. Sahiwala, learned senior counsel, assisted by your name? A.R. Pal, for the petition. Also heard Sri Bora, J. Bora, learned standing counsel. What do you call yourself?
For ATPF.
APTF,
ATEPF.
ATEPF. Full stop. Para, Sri Bora has submitted that affidavit in opposition has been filed on 13/1/2026, in which lot of ambiguities on the part of the petitioner have been pointed out. He has submitted that unless satisfactory explanation is able to be given by the petitioner, registration would not be possible. Full stop. He otherwise contends that if the application is filed with all the clarification, there would be no hindrance at all for such registration, which is mandated by law. Para? Sri Sahiwala, the learned senior counsel submits that explanations will be put on record by way of an rejoinder affidavit for which he prays for and is granted 3 weeks' time. Full stop. Para? We give your date list on
Yes.
on 17th, is it okay? 17th of August.
Right.
Item 10.
The respondent 3 has filed affidavit. I will be allowed 1 week time, Lord. I'll.
Who is free? Madam, you are 3.
District Commissioner has filed.
Okay. Okay.
By 31st, I'll.
Sri G. Bukolia, learned State Council has submitted that affidavit in opposition has been filed. Full stop. You are 3, R3.
Yes.
Who's first 5, 6, 7, 8, and 11?
The private respondent, they have filed, my lord.
Your name, madam? R. Sharma. Miss S. Kulita, learned counsel appearing for the respondent numbers 5, 6, 7, 8, and 11 has also informed of filing of such affidavit. Para. Ms. M.D. Bora, learned standing counsel cooperation department is also present. Para. Present. Who submits that the said department is a formal party. Para. Sri Haloi, K.M. Haloi, the learned counsel for the petitioner, submits that he may be allowed time to file rejoinder affidavit.
1 week may be done.
Para. On request, matter is adjourned to be listed on, we can have it on 31st July. Is it okay? Can you file it by 31st July?
I'll file by 31st July or on 4th or 5th July.
We can have it on then 10th of August or 7th of August. 7th of August, is it okay?
7th.
7th of August. By which time the rejoinder affidavit within bracket as bully kori diba, huh? 200 of affidavit within bracket as may be filed.
Much.
Is there any interim order?
No.
14.
May it please your lordship. Lordship, on the last date of listing, some instructions were sought and they were directed to file an affidavit.
14, these are item number?
Item number 14, my lord.
Time blow na jano. As botha koro logot. 14 to belek kai asil. Oh, that was in kiman. 12, 13, and 15 asil niki etu. Oh, 14 to baki asil niki. Oh.
Where everything is caption, my lord. It's a very good, vehicles bill, my lord.
Okay. When can you get the instructions?
Well, 3 weeks time maybe. It's
Okay.
very old bills, my lord. Even 19, 20, 21.
How is it maintainable, Mr. Chetri?
And there is no admission.
If there is no admission, you go before the particular civil court.
Lordship, let them clarify, my lord, through affidavit. I will counter that, my lord, afterwards. At
First,
least
you
let
have
them
to
file an affidavit, my lord.
First, to entertain this, you have to show us that there is an acknowledgement by the head of the department or chief engineer. Where is the acknowledgement?
Lordship, we have submitted a representation before the Director General of Police.
No, no, acknowledgement. You filed your affidavit. There is something on 18/3/2020 by the SP requesting for funds. You should point out where you should immediately point out page 19. 19, there is some, there's a document which might favor you. You should do some homework and come to the court. Heard you were Asupadhyay, heard Sri Asupadhyay, learned counsel for the petitioner. Para Sri Bokolial, the learned state council, prays for further time to file affidavit in opposition. Full stop. List on 10th of August.
I am highly obliged.
Maybe no, in this case, the petitioner made
Yes,
prayer for
response
the
returns, state council,
27/5/26 order make ambiguity.
now we have seen the notice history. Yes, state council, response.
Forest.
I think this is forest department.
Forest.
Mr. R. Gogoi,
Mr.
D.
R. R.
Gogoi,
Gogoi.
I. Borthakur.
We relied on an order passed in a similar matter.
What is the issue, Mr. Goswami?
My issue is, my lord, we were settled with some mining areas, my lord.
Then,
my lord, we made the payments, my lord, all the requisite payments we made, my lord. They failed to hand over possession. There are some local issues, my lord, and that the department itself admit. Now there were 3 contiguous mining areas. In the other 2 contiguous areas, my lord, same thing happened, my lord, no handover of possession. And they are also, they deposit money. They drew up, my lord, Bakizai proceedings against them, that you continue to pay your leftover kiss monies. While admitting that from their side only, my lord, they lodged Azahas with the police, my lord. But in those cases, they had approached the Honorable Court and this order was passed. Now, in the present petitioner's case, my lord, that Bakizai proceedings was not drawn up. So therefore, he was trying with the department, my lord. But since nothing has happened and this order was passed, thereafter he has come. So the court wanted to know whether if it is similar, we'll pass on that instruction as on the even a learned counsel is not there. Your lordship will note, my lord, almost 23 lakhs of money.
wait for a while, Mr. Goswami, let Mr. Gogoi,
D. Gogoi, my lord. First counsel D. Gogoi.
he will come. After a while.
Well,
Yes, Mr.
Lordship, page 14 is the liability statement, Lordship. It's a admitted amount and part payment already made, Lordship.
Notice was issued, yes, your,
Not admitted, that way, madam. There is a notification by the chief engineer.
you filed your affidavit, okay. Heard Miss K. Chaudhary, learned counsel for the petitioner. Who, petitioner, full stop, notice was issued on 5/6/2026, para. Miss P. Chakraborty, learned standing counsel, Water Resource Department, has however submitted that there are certain objections which she would like to put on record by way of an affidavit. Also heard Miss A. Gayan, learned CGC. Para, let the matter be adjourned by 4 weeks to enable filing of the affidavit by the respondents, ipso advised. List on, madam, date, you tell, suggest a date. 12th, no, 12th will be too early or what? 12th will be early, I think 17th. 17 August.
My lord.
17 August.
Public.
May I present?
There are two affidavits on record filed by respondent number 1 and respondent number 4.
Who's for the other side? CGC?
One is donor, one is PWD and one is
Contesting, who's contesting? PWD, Mr. Chaudhary?
PWD is contesting and donor has filed respondent
Who
number
is
1.
representing donor? CGC?
CGC, I think.
Affidavits filed.
Yes, affidavit by respondent number 1 and respondent number 4 are on record.
Both have filed affidavit.
Yes.
You would like to file rejoinder?
No, I don't think so.
Then we can have it for disposal
Yes, Your Lordship.
if you are agreeing.
Yes,
Can you have the, who has the role? Both?
yes, because there was a sanction amount. So
What is your dispute?
my dispute is the amount have been approved, but it has not been released.
Approved by the donor ministry.
Yes, and they have
Released
given
by
the
whom?
certificate also yet admitted. the
Release
amount.
will be, have to be given by the Public Works Department.
Yes, they have approved the payment, but still they have not disposed of the thing because they are saying some sanction dispute among the two parties. Your Lordship.
Mr. Chaudhary?
Exceed the milestones.
You have received the money.
Yes.
The completion certificate has been issued to us.
What is the issue for which you have not been able to release?
Their stand is that amounts means there is some internal between the two parties because it was 50, 90,
10.
10. 90% by the donor and that 10% by the state government. Then thereafter, during the course of the execution, they gave us an extension also. Thereafter, they said that the scheme has been stopped, so it was foreclosed. However, the amount which we executed, completion certificate to that extent was issued. And the amount to be disbursed in our favor was also certified. But that has not yet been disbursed.
Yes, Madam Devi, you are appearing. Yes. Can you take up the takings up for disposal? Can this matter be taken up for disposal?
Lordship, first of all, I'll take your Lordship to Annexure B. The facts is same here. The NIT was issued, I participated.
No, you give us the background facts.
Yes,
Give us the background facts. What had happened?
first of all, your Lordship may kindly come to Annexure B, your Lordship.
B. You tell us the facts, we'll just
The
record the
facts
facts.
is, your Lordship, I was given a contract.
There was an NIT.
There was an NIT. NIT was issued
Date?
on 17/8/2018, Annexure C, your Lordship, page 51.
2018 NIT, page 51.
51, your Lordship.
51.
151, your.
Yes, 17/8/2018, there was an NIT.
Yes,
You participated.
yes. I participated.
And NIT for?
Thereafter,
NIT for? Notice was for?
pardon?
What was the work for?
The work was construction of road from NH 31 to Kashimpur, Sapal, Kuch.
Construction of road.
Yes,
Thereafter, you participated.
yes. I participated in the same. Thereafter, they gave the letter of acceptance in our favor on 6/10/2017, Annexure E.
610?
6/10/2017.
How can it be 7? NIT, you said it is 2018.
Sorry, 6/10/2018, your Lordship.
6/10/2018.
Page 160.
160.
160.
LOA in favor of petitioner.
Yes. And we asked to notice to proceed was given because there was a sanction letter later on. What had happened is they gave the thing, the sanction letter came approval later on. The notice to proceed came on 25/10/2017.
17?
Yes,
Cannot be.
it is coming out from the yellow.
How can it be before the
No,
NIT even?
Just give me 5 minutes, your Lord. আপনি যে note করেছিলেন একটু পড়ুন। Sorry, it was 17/8/2017, NIT.
17,
Yes.
okay.
The
And
relevant-
LOA is 6, 10, 17,
Yeah.
probably.
Your lordship will get it, the relevant page on page 53, though it starts from page 51. It is at page 53.
Doesn't matter, LOA dated 6, 10, 17 probably then.
I'll tell your lordship, 17/8/2017, letter of acceptance 6/10/2017,
17.
and notice to proceed is 25/10/2017.
Notice to proceed.
Yes. And it was directed to be completed within 24 months. That was, target was 25/10/2019.
Yes.
Now, your lordship will find in annexure G, page 165, the first approved RA bill in my favor was granted on 4/10/2018. Page 165, your lordship.
Yes.
After that, your lordship will find an extension was granted in my favor for till 4/24/2020 by annexure I, page 169. Subsequent thereto, in between, there were various correspondence among the respondents with regard to sanctions of the amount for the particular project.
We'll take a break of 5 minutes.
Lordship, after the extension was granted by annexure I till 24/10/2019.
Page 169.
Yes, your lordship.
Hmm.
Thereafter, a progress certificate was issued by the respondents. Your lordship will get the same at page 172, annexure K. This was the progress certificate, annexure K, issued in respect of the work which was entrusted to us for completion, your lordship. Now, at the bottom of this letter, your lordship will find present bill value was given as 90 lakhs, 99,940, your lordship. Thereafter, your lordship, a final payment certificate was issued at annexure K1, your lordship. The final payment running account bill C, page 173. The relevant, after the calculation, your lordship will find certified at page 175, the total amount certified was again stated in the second last column, 90 lakhs 59,940. If your lordship has got it. Page 175.
170?
Page 175. Annexure K1.
Yes.
This is also certified by the respondents that this is the amount payable to us at that point of time. This was issued in favor on 1/11/2000. Sorry, this is a letter dated 22/21 at the bottom of the signature, page 175. Now, thereafter, this particular work was foreclosed because the scheme under which it was sanctioned, I think there was some, your lordship will find at page 176, annexure L. If your lordship has got it. With reference to above, this is by the executive engineer to the chief engineer. With reference to the subject cited above, have the honor to foreclose the above mentioned work, observing all necessary formalities as per tender agreement. The incomplete final bill has already been prepared before handing over the site to the concerned contractor, PMGSY scheme. The work has been foreclosed as the scope of the work is not covered under the said scheme, so the proposed road is considered under PMG this in favor of. So this was foreclosed. Thereafter, your lordship will find there was some requirement for budget allotments, etc., and a series of letters. Now I'll take your lordship directly to annexure L, your lordship. Sorry, not annexure L. Your lordship will come to annexure O, page 187, your lordship.
This is the utilization certificate. Issued by the executive engineer. And here in page 195, the final certificate, sorry, not 195. The utilization certificate is given, and whereby the amount sanctioned means the state share, etc., is given in page 193. It is given here thereafter. In annexure P, the completion certificate was issued after the utilization certificate. And in annexure P at 197, at the bottom, present demand value was issued for 81 lakhs 53,946. That is the central share. They sought for the central share for the payment to me, Your Lordship. Thereafter, it is completely silent. In spite of my repeated requests, the payments have not been released in my favor, though a certificate, as Your Lordship had seen at page 175, the amount is there. Now, there is a dispute for the sanction amount being released by the center and the department. And though a certificate has been given with regard to the completion 100%, the amount has yet to be disbursed in my favor, Your Lordship.
Amount is lying with whom?
With the department, Your Lordship,
Department means Public Works,
the PWD, Your Lordship.
Public Works.
Yes.
Now, the amount has been given to the Public Works Department by central government.
They are saying, they have stated in their stand that they have disbursed it. But the amount, the PWD is saying that they have not received it. Means that is the dispute, but I am not, means my performance under the contract was done as per the contract.
Where is the amount? Now this 81 lakhs 53,000 odd is the central share or state share?
It is the central share because that is the amount. At the bottom, it is written central share. In the, if Your Lordship sees page 187, in the bracket present demand 81 lakhs, within bracket central share, it is given, Your Lordship.
Now, yes, where is the amount, Madam Devi? Is it lying with you or have you released it to the Public Works Department?
Annexure A page 208 of our affidavit, Lordship.
Page?
Page 208 of our affidavit.
8.
Lordship, this is the sanction letter.
8.
Added.
Your affidavit.
Lordship.
This I have already annexed as annexure B, Your Lordship. This is the same document.
This.
Amount of 506.31 lakhs was sanctioned by the central government, Lordship. It was 90% of the total cost of rupees 559.57 lakhs. As per the
Paragraph.
90% central share, Lordship, and 10% state share. Now, Lordship, second, 209 is, Lordship. Yeah, the condition has been, condition to release this amount has been selected, Lordship. 2, para 2, approval of Ministry of Development of Northeastern Region is subject to following conditions. C, Lordship.
Hmm.
The fund shall be released by Ministry of the Honor in 2 installments. The first installment will consist of 40% of central share of assistance, and second installment will be for the balance central share of 60%. A token amount of 10 lakhs will be released by the ministry as part payment of the first installment, so that tender formalities could be initiated and finalized by the state government within 66 months. Thereafter, the state government will approach the ministry with a copy of work order award letter for claiming the release of balance amount of first installment of funds. Next, Lordship. The second installment of central assistance will be released by the Ministry of Donor once the state government has mandatorily released and utilized full state share and the physical progress is not less than 50%. Further, release of second installment will be preceded by state government furnishing utilization certificate of entire amount of release of first installment of certain share and state share release along with physical and financial progress report duly signed by the secretary of the implementing department and confirmation by him. So subject to these conditions, Lordship, this two installment is amounts are released. First installment has been released, Lordship. First, as a token money, 10 lakhs were released on 19/6/20.
No, we are not on this internal thing, what has happened in the intermediate stage. What has happened to the final demand? Have you released the amount? We are not on condition fulfillment. Have you, as a matter of fact, have you released?
He could not complete the project, Lordship.
Who, the petitioner?
The petitioner could not complete the, and also state government could not submit the utilization certificate. Therefore, the second installment was not released.
Second installment not released. Tell us that second installment not released because
First installment released, Lordship, 175 crore.
utilization certificate is on record, Your Lordship, page 193. And Your Lordship will find on page 190, it is an admitted thing that it is foreclosed. I could not complete it because it was foreclosed, but 100% completion is there to the extent before the foreclosure. And the utilization certificate we have already annexed, which was sent by the state towards to the donor.
Lordship, our reply to at page 204.
What requirements he did not fulfill? He could not complete the work, number one.
Even 50% he has to complete. He is must be completed 35%. 35%, and it was foreclosed, and also the state government could not submit the utilization certificate. Para 11 maybe.
Okay, two reasons you have cited for justifying non-release of the second installment. One is non-completion of the work by the petitioner. He had only done, he is required to do a minimum 50%. He has done only 35%. And secondly, the state government is required to furnish an utilization certificate which has not been done. So under those circumstances, you will not release the second installment because they could not fulfill the condition.
Yes,
that is your stand.
Lordship, para 11, Lordship.
11 of your affidavit.
Affidavit 204. May I read?
Your affidavit starts at 2, not at 204, it starts at 215. It's not 200, okay? There's paginations have been changed. You're referring to paragraph 11
Yeah.
at 219.
May I read, Lordship?
That with regard to the statement.
Yes, Lordship.
Yes.
That with regard to the statement made in para 10 of the repetition, the deponent begs to state that there was no progress of the contract work and demand of funds received from the state government. No progress of the contract work and demand of funds received from the state government till 26/6/2023. But the funds remain unutilized for more than 3 years with the state government. Therefore, the Ministry of the Honor took comprehensive decision for all delayed and stalled projects by letter dated 26/6/2023 under intimation to state government to withdraw funds authorization for such projects as per details list in the letter under reference. The net fee was further directed to deposit the remitted amount against the project rupees 94.14 lakhs unspent amount for this project to Consolidated Fund of India. Consequently, net fee issued a demand draft to EAO New Delhi for said transfer at letter dated 5/7/2023. The Ministry of the Honor sought a clarification from the state government on the matter of foreclosure was letter dated 3/8/2024. The government of Assam had letter dated 22/8/2024 stated that the project has been foreclosed with the approval of CEPWD Assam. The state government by letter dated 22/8/2024 submitted the utilization certification for the project stating that an amount of 80.007 lakhs has been utilized. It was further informed that the contractor had miserably failed to complete the work even after giving ample opportunity for the interest of the work. The progress of the work was very slow, that is 36.89%, even after the extended time and repeated notice to contractor. The CEPWD approved foreclosure of the work on 20/7/2021, and it was informed by the state government of Assam that the balance work was later sanctioned under PMGSY 3 scheme. Hence, further release of funds against the project would not be processed by the ministry owing to the fact that the ministry was not intimated by the state government regarding the foreclosure of the project and partial execution of the project under another scheme of Government of India. These are from Annexure E onwards.
Yes.
So this is the reason why the remaining amount has not been sanctioned.
Mr. Biswas, if you have not fulfilled the amount, the conditions, how do you expect the amount to be released?
No, your lordship, they are saying they have, it is just, and but if your lordship sees the state government's letters to me, etc., your lordship, I will take your lordship again to the.
We'll come back to you here, Mr. Chaudhary first.
Yes, sir.
Anything else, Madam Devi? Yes, Mr. Chaudhary.
Okay, here, basically at page 202, paragraph 4 of our table, we have stated that he, in spite of repeated communication, he has not been able to achieve the milestones. And lordship, only 25% of that work was completed. And lordship, he was also given communication notices to speed up the work at paragraph 5 we have stated, but in spite of that there was no such progress, and ultimately at paragraph 8 we have stated that as per clause 0.6 clause 1.1.1.17
Clause?
lordship, it's a long one, 1.1.1.17 and 28.
Page.
It will be page 80 of the tender document. That is not annexed.
Have you mentioned in your affidavit?
Yes, lordship, paragraph 8, and we have annexed the relevant page. Lordship, paragraph 8 is the mention, and annex of 5 page.
Your respondent number?
Respondent number
4.
Your
Your affidavit starts at page 200.
200. And paragraph 205, paragraph 8 at page 205.
Paragraph 8 at page 205.
Lordship, the contract data where the achievements are mentioned at page 214, annex of 5.
Non-achievement of milestone.
Yes, Lordship.
Mr. Biswas, in view of such categorical denial on facts,
Yes.
how do you expect an order from the court?
Your Lordship, in page 169, it is there. After this particular letter, it is on record, Your Lordship.
No, but on affidavit, they are stating that you could not achieve the milestone.
It
Both
is,
the authorities are saying.
They have stated
If
in
you say
annexed
that, no, in spite of this projection may not be correct, then aren't you required
No,
to?
I know there is a dispute with regard to factual facts I cannot emphasize upon that.
You may be correct, but we are not in a position
No,
to declare you to be
question
correct.
of facts, Your Lordship.
Declare you to be correct.
Yes.
We cannot. More so when the authorities themselves on affidavit.
Because
You approach the civil court, Mr.
yes. However, another thing is there, though they have taken a plea of arbitration, it may not be possible for me for arbitration because two parties are involved. I have entered only with
None of them have raised arbitration.
one of them taken a plea that there is an arbitration clause, but the fact remains.
Arbitration of you with the PWD.
I have PWD, but donor is also involved. I cannot.
Then you can plead this.
That can be there.
Okay. Heard. 3. A. Biswas, learned counsel for the petitioner. Also heard Ms. R.D.B., learned CGC, and Sri B. Chaudhary, learned standing counsel, PWD. Full stop. The instant application under Article 226 of the Constitution of India has been filed for a direction for release of contractual dues amounting to rupees 99,48,909. Full stop. Full stop. It is contended, no, with interest. Para. It is contended that the petitioner had participated in a notice inviting tender dated 17/8/2017, pursuant to which he was granted the letter of acceptance on 6/10/2017 for the work, namely, within inverted comma, Sailabaha, construction of road so and so. Upon such, thereafter, notice to proceed was issued on 25/10/2017. Full stop. It is submitted by the learned counsel for the petitioner that while the completion tenure was fixed at 24 months, there was extension granted depending as the situation had demanded. Full stop. It is also submitted that the first approved RA bill was granted, and till 24/4/2020, the 2020 or the first extension was granted, correct?
Yes, sir. 24/10/2019.
24/4. No, it was granted till 24/4/2020, I think.
Yes. There was
until 24/4/2020, the first extension was granted. Full stop. The learned counsel has also drawn the attention of this court to the progress certificate wherein the bill value was mentioned, and also the final payment RA bill wherein the amount in question, wherein the amount has been mentioned. Full stop. He has also submitted that due to certain change in policy, the work was foreclosed. Full stop. Nonetheless, the utilization certificate was granted on 18/3/2023, and also the completion certificate as per which an amount of rupees 81,53,946 being the central share was reflected. Full stop. The learned counsel for the petitioner has submitted that under such circumstances, it would be wholly unreasonable to withhold the amount, full stop. He has submitted that under the scheme in question, comma, 90%, the sharing pattern vis-a-vis the central government and the state government is 90:10. Full stop. Para. Per contra, comma, Miss R. Devi, while not denying the that the work is under a scheme, comma, has submitted that the central government is required to release the funds in 2 installments, and the first installment was released. Full stop. However, comma, the second installment was not released as the petitioner could not fulfill the requirements, namely achieving at least 50% of the work. Full stop. And the lack of the state government to furnish utilization certificate. It is contended that the petitioner could complete only 35% of the work. Full stop. Para. Supporting the stand of the central government, comma, Sri B. Chaudhary, the learned standing council, Public Works Department, has submitted that only 25% of the work could be completed by the petitioner. And in spite of numerous notices to speed up the work, comma, no progress could be achieved. Full stop. He has also drawn the attention of this court to clause 1.1.1.17 and 28, and has submitted that due to non-achievement of the milestone, comma, the amount cannot be released, apart from the fact that the second installment is yet to be released by the central government. Full stop. Para. Sri Biswas, in his response, has denied the contention of the respondents that the work could not be completed, that the work could necessary progress could not be achieved by the petitioner. Full stop. He has submitted that the documents would show that sufficient progress could be achieved, which is supported by the completion certificate as well as utilization certificate. Para. Upon considering the facts and circumstances and the materials available before this court, comma, it clearly appears that the dispute would be within the realm of disputed questions of fact, which a writ court would not be in a position to enter and adjudicate. Full stop. While this court has also noticed that such disputes have been placed on record by way of affidavit and therefore has to be taken into consideration. Para. Under those circumstances, comma, while this court is not inclined to enter into the realm of disputed questions of fact, comma, the petitioner may not be precluded from seeking redressal of his grievance before the competent civil court. Full stop. At this stage, comma, Sri Biswas, the learned counsel, has also submitted that the Public Works Department has taken up the objection of availability of arbitration clause. Full stop. He has submitted that since there is involvement of the central government in the dispute, comma, redressal of his grievance may not be able to be completely done in an arbitration. Full stop. Para. Considering the above, comma, the writ petition is closed by giving liberty to the petitioner to approach the appropriate civil court as noted above, comma, a full stop. The petitioner would also be at liberty to take up the plea plea that the arbitration clause would not be an absolute bar for adjudication of such disputes. And if the same is taken, comma, the learned civil court would consider the same and proceed with the matter in accordance with law.
Lordship, with regard to limitation, Your Lordship, any observation?
When did you file this? 25. When did the cause of action arise? We cannot say that.
Because it was,
We could have said if we had come before the High Court immediately.
we had come, Your Lordship, because this stand came,
We can only say from the period
yes,
when
yes,
the
only for that period.
the petitioner would also be at liberty to take up to take up to take the aid of Section 14 of the Limitation Act 1963, which, if done, would be considered by the learned court in accordance with law.
Obliged.
Because it says in an forum without jurisdiction. You cannot say without jurisdiction.
Yeah, understand. Obliged.
So, Your Lordship, one matter was.
No problem, no problem.
I saw this, so I will just 5 minutes, I will take question. Just 5 minutes, I will take question. Here the.
For now, we have not heard him.
Oh,
We have not heard him. We have just had a cursory
no, Lordship.
overview. He is saying that there is a jurisdictional error
Lordship.
because the matter ought to have been raised before the appropriate labor court through a reference and the issues to be framed by the appropriate government pursuant to the dispute forwarded by the learned conciliation officer. Now the adjudication has itself been done by the labor officer. That is the, and he is also relying upon something which it just indicated. We have not heard him properly. We'll just take 5-10 minutes of Mr. Sharma, then we'll come back to us. Issue appears to be very simple.
Lordship, we are basically aggrieved by the order dated 17/7/2024, passed by the Labor Officer Dhemaji, asking us to pay the wages as per the Mazithia Wage Board recommendation.
Page
67. Basis. Yeah, I'll only limit my argument to the jurisdictional error without going to the merit, because anyway, he has not given any reason as such why that amount has to be paid.
.67 is your impugned communication.
Yes.
Okay.
Well, if your lordship can take this judgment, Abhishek Raja, 2017, 8 SCC 435.
2017,
Yes.
8 SCC.
Yes.
Page, paragraph.
Paragraph 2. I'll just rely 4-5 paragraphs. So we are basically concerned with this. Your paragraph 1 says the working journalist relevant act. It's working journalists and other, is paragraph 1 itself.
Yes.
The working journalists and other newspapers employees, condition of service and miscellaneous provision act 1955. We are concerned with that act, Your Lordship. Because the wage boards are constituted under section 9 and the recommendation of the wage boards is approved by the central government under section 12. Paragraph 2. May I read that?
Just a minute, miscellaneous provision. This is the act, so
Yeah.
paragraph 2, yes, please.
Yes, paragraph 2. So far as the fixation and revision of wage is concerned, section 9 of the act has left such fixation and revision of wages in respect of working journalists to be dealt with by a wage board constituted hereunder. So section 9, it is constituted, and the recommendation of the wage board, if accepted, are to be notified by the central government under section 12 of the act.
Yes.
And next page, your lordship.
Yes.
Next page, paragraph 5, section 17 deals with the mechanism if the recommendation of the wage boards are not accepted by the or not implemented by the newspapers establishment, what they have to do. Section paragraph
After
5.
notification.
Yes.
After 12
After 12,
notification.
yes. So
Those are okay. 17 is the consequential.
consequence.
Yes.
But before that, your lordship can turn to next page, how this Majetia wage board came into effect. There are 2 paragraphs.
No, those may not be necessary, Mr. Sharma.
Yes.
Come to the issue directly.
Issue is dealt with here itself, because what has happened, your lordship, how Majetia wage board was constituted, and while this recommendation was published, there were many repetitions in file directly to the Supreme Court challenging those recommendations by all newspaper establishments throughout India. Then during the pendency of this repetition, section 12 notification was issued. So there was repetitions were amended to challenge that section 12 notification, this
Correct.
Majetia wage board. Then Supreme Court.
Just a minute, just a minute.
That is in para 7 and 8.
Yes.
So 7, 8 and 10 is those paragraphs which gives this background, your lordship.
Yes.
So ultimately, Supreme Court upheld those section 12 notification as well as the recommendation of the Majetia. So that has to be implemented. Now, since those
What happened to the repetitions 12?
They were dismissed.
Dismissed.
Yes. That was 7, 8 and 10.
Oh.
Now, they were all newspapers were finding it difficult to implement those. So contempt proceedings was filed before the Honorable Supreme Court.
Yes.
This is this judgment, which says if a lordship turns to paragraph 29 at the last, because they deal with the scheme of that act which I just pointed out, your lordship. Paragraph 29, last page. This may I read that? That is a finding of this.
Yes, please.
Yes, having clarified all doubts and ambiguities in the matter, and upon holding that none of the newspaper establishments should, in the facts of the case before us, be held guilty of commission of contempt, we direct that henceforth all complaints with regard to the non-implementation of the Majetia Wage Board award or otherwise be dealt with in terms of the mechanism provided under section 17 of the Act. It would be more appropriate to resolve such complaints and grievances by resort to the enforcement and remedial machinery provided under Act rather than by any future approaches to this court in exercise of contempt jurisdiction of the courts or otherwise. So it's non-implementation or otherwise, whether that person is an employee or entitled to Majetia Wage Board or employee, has to be dealt at section 17.
Yes.
Section 17, if I may read again, if your lordship come back to para 5, I have shown that. Para 5.
Para 5 of which act?
Of this judgment, they have quoted this. Yes.
17.
Yes. First para is that the 17 number subclause subsection 1 is relating to that they have entitled to receive payment
Yes.
in terms of the wage board recommendation.
Hmm.
Now, I am concerned with subsection 2, your lordship. If any question arises as to the amount due under this act to a newspaper employee from his employer, the state government may on its own motion or upon application made to it, refer the questions to the labor code constituted by it under the Industrial Dispute Act or under any corresponding law relating to investigation and settlement of industrial dispute in force in the act, and the said act or shall have effect in relation to the labor code as if questions so referred were a matter referred to the labor code for adjudication under the act. So that is my first submission. That's they have filed a complaint, whether they're entitled or not, we have disputed that his complaint or his claim. Thereafter, the labor officer ought to have sent it to the state government for reference. And the section 17 of this Working Journalist Act was also came into consideration by Honorable Supreme Court in another judgment, which I have sent, just passed on, Lordship. 1987 3 SCC 507 years. The second one, Samarjit Ghosh.
You have given the act. You have given two judgments.
I'm
No, you have not given
Right.
judgment. Paragraph?
6. That's one paragraph. They're considering the section 17 of this act, Working Journalist Act,
1987.
3 SCC 507,
Para 6.
para 6.
Yes.
When all the provisions of section 17 are considered together, it is apparent that they constitute a single scheme. In simple terms, the scheme is this: a newspaper employee who claims that an amount due to him has not been paid by his employer can apply to the state government for recovery of the amount. If no dispute arises as to the amount due, the collector will recover the amount from the employee and pay it over to the newspaper employee.
In the form of almost a baki jai.
In a form of, but if a question arises, which is again subsection 2, if a question arises as to the amount due, it is a question which arises on the application made by the newspaper employee, and the application having been made before the appropriate state government, it is the state government which will call for an adjudication of the dispute by referring the question to a labor court. When the labor court has decided the question, it will forward its decision to the state government, which made the reference, and thereafter the state government will direct the recovery proceedings should be taken. So my humble submission is that he didn't have jurisdiction to decide on the dispute. Rather, he should have referred the dispute for reference to the appropriate state government, which is the government of Assam.
This decision is by whom?
By
labor officer.
By the labor officer Dhemaji. Act no, rule form. 57. Rule form 19.
Okay.
Then the another jurisdictional point I am taking, your lordship, is that it is a categorical statement that we don't have any offices in Dhemaji. If your lordship says rule 37.
That you have already given. This you have
this
given.
is a
This you have given.
yes.
This is the other. We'll retain this one. Go to same page 19 asile, 11 asile. We can't actually have.
So these are the rules of lordship that has been framed under the act.
Yes.
As per rule 37, rule 37. Rule your lordship, sorry, rule 36. It
36.
is in flag mark, your lordship.
36, yes.
Yes, it is a conciliation officer. The one who will have jurisdiction is where the registered office or the central office or the branch office of the newspaper is located, your lordship. We don't have any offices in Dhemaji. and the central office is situated in Gauhati. So it is a labor officer or the conciliation officer in Gauhati who will have the jurisdiction. That statement we are given in para 21 and para 22.
An application under section 17 of the shall be informed C to the government of the state where the central government. Okay.
So this two are my only jurisdictional point where he, first of all, he should not have decided. He should have referred it. Second is that he anyway doesn't have jurisdiction. It is a labor officer in Gauhati who has jurisdiction to hear both the parties, and if there is dispute, then to refer it to the government of Assam. That is my, so I'm praying that this order may be set aside and remanded back to the appropriate labor officer to hear the matter afresh, and thereupon take appropriate.
Yes. Mr. Gogoi for Gogoi for whom? One is the workman.
No, I'm right. State of Assam, second level, 1 and 2, 120.
Yes.
See, the jurisdictional part was already, that part was said by our High Court also, see, one of the cases was. If there is a dispute lawsuit, then it should go to the lawsuit. There is a lawsuit, second proposition of laws. Otherwise, the labor officer has the jurisdiction. It was also decided by the Honorable Apex Court. Here, paragraph 6, lawsuit quoted the, I just indicate the paragraph 6.
Paragraph 6.
Paragraph 6 quoted the statutory prescription lawsuit.
What is the date of this?
Is in, it was also reported lawsuit, but I am not in the reported business.
It doesn't matter.
122 lawsuit. No. 21 to 22 lawsuit.
Paragraph?
Paragraph 6 is the lawsuit, statutory prescription lawsuit.
Mm.
Then my lord may kindly come to lawsuit. Paragraph 11 onwards discussion part lawsuit.
Eleven.
Page 14 lawsuit. Paragraph 11 onward, paragraph 11 lawsuit. Then paragraph 12 lawsuit. Paragraph 11 lawsuit.
Yes.
Paragraph 11 lawsuit. Paragraph Honorable Supreme Court judgment, that paragraph was referred lawsuit.
Mm.
Summary close judgment lawsuit. Then my lord, paragraph 12. Paragraph
12.
Paragraph 12 lawsuit. Paragraph 12 lawsuit. Next page lawsuit. Next page. Last. Above three lines, if no, my lord, got it lawsuit, if no.
If no.
If no lawsuit. If no dispute arises as regards to the amount due on the basis of the direction issued.
That is subsection 1.
Subsection 1. Subsection
1.
So
It is almost identical to a Bakijai proceeding.
No, 17.
Through the collector.
No, through the collector, if there
Yes.
is no dispute. If there is a dispute loss, here my friend has indicated that they have the disputed loss. Then it should go to the labor court. It is the proposition of the law. Here also, if no dispute arises as regards to the amount due on the basis of the direction issued by the state government, the labor commissioner in the instant case, the collector would recover the amount from the employer and pay it over to the newspaper employee loss. If a question arises as to the amount due, then in that regard, the state government will call for an adjudication of the dispute by referring to the questions to labor courts. The labor court shall then decide the questions and forward to each state government which made the reference, and thereupon the amount found due to the labor court may be recovered on the manner provided under subsection 1 lawsuit by issuing appropriate direction either by the state government or the labor commissioner. This is the proposition of law. Otherwise, the lawsuit, the power, jurisdiction power also decided by one of the Honorable Rajasthan High Court, where indicates that lawsuit the Honorable Supreme Court judgment. That's right.
What about the other aspect? We are, first aspect is very clear,
First aspect lawsuit.
on that referring to labor code. What about the territorial jurisdiction, even otherwise?
Territorial jurisdiction lawsuit, it is done lawsuit, my lord, for that purpose, my lord, kindly peruse page 42 lawsuit, page 42. 42 the writ petition law.
Yes.
42. You see, it was issued by the labor commissioner to the labor officer Dhemaji lawsuit. Labor officer Dhemaji lawsuit. And on the basis of that lawsuit, page 67 order was issued lawsuit. So delegated the power by the labor commissioner to the labor officer Dhemaji lawsuit.
Local person of the Now, in this regard, you are requested to submit a detailed inspection, action taken report.
Lawsuit.
So rather his views were taken into consideration.
So here, the inspection and action taken report also in the action taken report also he may interpret. He may interpret in the different way also. Action taken report also. Then my lord, page 67 also.
Page 7.
Page 67 also.
The impugned order.
Impugned order was first, that on the basis of that lawsuit, that particular page 42 letter, where indicate that the lawsuit, the detailed inspection and action taken report, that part, action taken report lawsuit, that part he has done also. That particular order was issued, order was lawsuit, they had preferred an appeal lawsuit. They preferred an appeal lawsuit, so page 81 lawsuit. Page 81 is the commissioner's order lawsuit. Page 81.
Yes.
Page 81 lawsuit. The appeal petition preferred by the lawsuit petitioner lawsuit against the order passed by the lawsuit labor officer lawsuit.
Appeal is the appeal, there is no provision for appeal.
So lawsuit, on the basis of that lawsuit, there is no jurisdictional error lawsuit regarding passing of the order passed by the labor officer lawsuit, Dhemaji lawsuit. This is my humble submission. Because lawsuit, the power was delegated.
The power is only for making a reference.
So say reference.
If they are disputing, see there, if there is no dispute, 17(1) comes into operation. If there is a dispute, then it has to be adjudicated.
That is, it is settled promotional law lawsuit. Yes, because the order, when the 17 July 2024 order was passed lawsuit, it is not a disputed fact lawsuit, that was not disputed by the authorities also lawsuit. They have on the basis of the lawsuit claim petition which was filed by the petitioner, filed by the respondent lawsuit, that particular order was passed lawsuit. Yes, because now they have come with a, they have disputed it lawsuit. Then we have to apply the 17(2) lawsuit.
No, even at the stage of passing the impugned order
Lawsuit.
at page 67,
Lawsuit.
what adjudication process mechanism did he adopt?
They focused the lawsuit, the particular lawsuit
Management.
management authorities, and they have not replied, Lordship.
No, we have replied.
They have also, they have probably they have replied, Lordship. On the basis of that, that particular order was passed, Lordship.
Let us see your stand before the labor officer.
Page 66.
Page 66.
Yeah.
Yes.
Sri So-and-so occasionally contributed for news item along with photos of so-and-so for which he gets an honorarium every month. He gets so much and so much. He never got any official letter citing that he will be covered under the Majetia wage board. He just covered news item from Damaji as part-time correspondent. So though it's not that worded, but we are claiming that he's not entitled for Majetia wage.
Okay, we'll continue at 2 o'clock. Almost completed. Mr. Gauhati, what role do you have?
Is the.
No, he's a beneficiary. What?
The beneficiary.
Now, in the adjudication process, what will be your submission? Will you make submissions or? Okay, we'll come back at 2 o'clock.
No problem.
Here for the workman, the respondent, private respondent.
Respondent number 4 complaint. I lodged a complaint before the Labor Commissioner Gauhati, and it had referred to the district Assistant Labor Commissioner Dhemaji. Lordship, first and foremost, my affidavit in opposition, Lordship, page number 85, para 4. For a moment, Lordship, I have not taken so much time, Lordship.
Page number?
Page number 85, para 4, Lordship. Yeah, instead, it is now alleged that I am not a regular employee of their house, Lordship. It is not correct, as because of section 2C of the Workmen Compensation 1955 Act, Lordship. I am the legitimate employee of the under the instant writ petitioner house, Lordship. Section 2C, what says, Lordship? I have annexed it in I have indicated the page number 88. And second is there, Lordship, no jurisdictional error, I think, Lordship, as because of my board line have submitted, I am not take much time, Lordship. Labor Commissioner has competent authority to pass in such type of order, Lordship. That's why I'm, according to my point of view, there is no jurisdictional error. I have the legitimate employee. I have served 34 years armed service under the instant writ petition. After that, they have issued a termination letter 15/12/2023. Instead of superannuation, my age already become 60 years at that moment of time. They ought to have the superannuated me, but instead of that, they have terminated me without any rejoining assigning me, which was not which was contrary to the section 16A of the 1955 Act, Lordship. And lastly, Lordship, yes, I agree that there are disputed in case of amount, Lordship. Maybe
Mr. Gogoi, we are not entering into the merits of your dispute. You may have a good case, they may not have any case at all.
Lordship.
But we are on the aspect that who will adjudicate the dispute? Whether the Labor Commissioner has been given the power and authority by this Act of 1955
Lordship.
as interpreted by the Honorable Supreme Court
Lordship.
in the case of Abhishek, whether the Labor Commissioner would be the competent authority, and in this case it is not even the Labor Commissioner, it is a labor officer on the matter being referred to him. He had decided.
Lordship.
Now, the law has 17 has in very clear terms laid down, if the dispute is not there and the amount is entitled, then it can be recovered through by involving the collector.
Lordship.
Now, here is a case where they have raised a dispute that you are not entitled. or rather they're trying to justify their action in terminating you, or whatever, then this dispute has to be adjudicated by an authority under 3, subsection 3. 3 in clear terms says that the matter has to be adjudicated by a labor court on being referred by the appropriate government. Now that procedure does not appear to have been followed in this case. So we are on that. If you want to make any submission that yes, the labor commissioner has the power to make to refer the matter to a labor officer for adjudication by bypassing that, if there is any provision, then we can hear you. Otherwise, on merits, we are not expressing anything.
It may have to refer to the labor code.
So it's only on the aspect of jurisdiction and authority. Otherwise, on the merits of the dispute, we are not saying anything. Rest assured.
Only my humble submission, Lordship. I'm now 64 years old. Separate and so many ailment has done going to my health, Lordship. I'm in medical patient, Lordship, regular checkup, Lordship. That's why if the matter is referred to the labor code, starting interim relief has to be paid to me, Lordship. That's because of I have no option to circle.
So who will pay the interim relief? Does the labor code?
I have service long for 34 years.
No, interim relief, does the labor code is empowered under what provision? If there is a provision, you can invoke that provision.
Lordship,
But under a reference, there is no power of interim. Reference has to be answered by an award.
Lordship, in the case of WPC 1274/2018, Jonathan, Lordship, already submitted my learned friend, Lordship. There are certain indications, Lordship, as we to certain interim relief for interim relief, Lordship.
Which one, please?
Lordship. Para 17.
17.
Last page.
Yes, please.
Yeah, read.
What was the case in hand in that case? No, how many employees were there? Association was there. Association espousing the cause of all the employees. Now, have you quantified your claim? First, you have to quantify.
Yes, there are categories of newspaper establishment depending on the revenue collection, on circulation, and on advertisement. So they are category 1 to 6. It's not that they have to pay compulsory. And if they can show that.
No, we are not on that. We are on the intent. We are trying to examine his submission vis-a-vis the directions of this court in paragraph 17 in the case of Jona Hadaron.
Here his status as an employee is doubtful. And secondly, even the amount cannot be quantified because if the newspaper can show that the last 3 years they have suffered heavy loss, then they did not pay this. These are in the Mazikya Waste Board. That I have not placed before Lordship because that is not before, that's not be
Okay.
now. That will be by evidence whether we are supposed to pay, even if he is held to be an employee.
Okay, please write. Huh?
I have annex in my affidavit in opposition.
Regarding
Lordship.
what have you annexed?
I have annexed the calculation of my amount, Lordship, with the help of the Labor Commission of this, Lordship. Annex 3, page number, Lordship. In affidavit in opposition, page number 98, Lordship.
This will be difficult to be granted in as an interim relief. Yes.
an order dated 17/7/2024 passed by the labor officer Dhemaji, by which the respondent number 4, by which the petitioner has been directed to pay the respondent number 4 post-retirement dues by invoking the Madhitya Wage Board with effect from November 2011 is the subject matter of challenge in this petition instituted under Article 226 of the Constitution of India. Full stop. Para. Bereft of details, comma. The facts as projected is that the respondent number 4 had approached the labor commissioner with certain allegation, with some claims connected with the recommendation of the Madhitya Wage Board. Full stop. The labor commissioner vide a communication dated ... had directed the labor officer Dhemaji to look into the matter. Full stop. The labor officer, comma, Dhemaji, vide the impugned order dated 17/7/2024 had held that as per the documents submitted by the respondent number 4, comma, it was found that the wages received by him was not as per the recommendation of the board. Full stop. It was also found that recommended board during his tenure as a part-time local correspondent. Full stop. Accordingly, as a part of the post-retirement dues, the arrear amount was directed to be paid as per the recommendation of the board. Full stop. The calculated arrear wages were also enclosed with the said communication. Full stop. Para. I have heard Sri R. Sharma, learned counsel for the petitioner. I have also heard Sri K. Gogoi, learned state counsel, as well as Sri T. Gogoi, learned counsel for the respondent number 4. Full stop. The respondent number 4 has filed affidavit in opposition on 4/6/2025. Para. Sri Sharma, the learned counsel for the petitioner, has at the outset questioned the jurisdiction and authority of the labor officer Dhemaji to pass the impugned order. Full stop. He has submitted that the Madhitya Wage Board recommendation where the subject matter of deliberation and discussion in the case of the Honorable Supreme Court reported in 2017, 8 SCC 435. Full stop. In the said case, comma, the Honorable Supreme Court was in session of the working journalist and other newspaper employees within bracket condition of service bracket close and miscellaneous provision act 1955 read with the report of the wage board. Full stop. The learned counsel has drawn the attention of the said Act, more particularly Section 9, 12, and 17, which are extracted herein below. Full stop. He has submitted that the Honorable Supreme Court has clarified that he has submitted that initially the recommendation made by the Wage Board were put to challenge in the Honorable Supreme Court by a number of writ petitions. Full stop. During the pendency of those cases, the notification under Section 12 was published, and consequently, the said notification was challenged. Full stop. All the writ petitions were, however, dismissed, whereafter a contempt was filed. Full stop. The Honorable Supreme Court, in the aforesaid case of Abhishek Raza, has held as follows. Para 29? 29 quote করে দিব, huh? The learned counsel has submitted, learned counsel for the petitioner has submitted that in an earlier case, has also referred to an earlier case of the Honorable Supreme Court reported in 1987, 3 SCC 507, Samarjit Ghosh, and the observations made in paragraph 6 are pressed into service, which reads as follows. Read as follows. Para 6. He has submitted that the labor officer would not have the jurisdiction to decide, and the proper course is to make an application for a reference by the appropriate government to the learned labor court, which would adjudicate the dispute. Full stop. The learned counsel has also drawn the attention of this court to the working to the rules framed thereunder, namely the working journalist conditions of service and miscellaneous provision rules, 1957, and has submitted that under Rule 36, the application under Section 17 of the Act has to be made in Form C, where the central office or the branch office of the newspaper establishment is situated. Full stop. He has submitted that neither the central office nor that the central office of the petitioner is not situated at Dhemaji, and neither there is any branch office at Dhemaji, and therefore the labor officer would otherwise also not have any jurisdiction to pass orders. Full stop. Para 3, the Sri Sharma, the learned counsel for the petitioner, accordingly submits that the impugned order be interfered with and the writ petition be allowed. Para. Per contra, please have your seat. Per contra, not per contra, no. Sri K. Gogoi, learned state counsel, has submitted that a coordinate bench of this court had the occasion to deal with a similar issue in WPC 1274 of 2018, which has been disposed of on 21/1/2022. Full stop. In the said case, by following the earlier directions of the Honorable Supreme Court, it was held that the proper course of adjudication would be by way of a reference. Full stop. The Learned State Council has, however, submitted that against the impugned order dated 17/7/2024, the petitioner had filed an appeal, which, however, was disposed of via an order dated 24/8/2024, as there was no provision for any appeal. Full stop. Para. Sri T. Gogoi, Learned Counsel for Respondent number 4, by referring to the affidavit in opposition filed on 4/6/2025, has submitted that he is entitled to the recommendation of the Wage Board, which was wrongly denied. Full stop. He has submitted that he had lodged a complaint before the Labour Commissioner, who had accordingly referred the matter to the Labour Officer Dhemaji, where the respondent number 4 reside. Full stop. He has also submitted that he is a legitimate employee falling under Section 2C of the Act, and instead of superannuating him and by giving the benefits, the management has wrongly terminated his services. Full stop. He has submitted that the impugned order is fully justified on the facts and circumstances, which may not require any interference. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully perused. Full stop. Para. As noted above, the Act of 1955 lays down the manner of constitution of a wage board, the recommendation, and the consequential action. Full stop. Accordingly, the Mazithia Wage Board had made recommendation which were the subject matter of challenge in the Honorable Supreme Court. And in the meantime, the notification under Section 12 was published, which was also challenged, which was also unsuccessfully challenged. Full stop. After in the contempt petition filed, the Honorable Supreme Court in the aforesaid case of Abhishek Raja had made the observations which have been extracted above, for full stop. The Act makes it clear that there are two components under Section 12, full stop. In case of dispute, in the case of dispute with regard to the recommendation, with regard to the implementation of the recommendation of the board, the same is required to be adjudicated by the Learned Labour Court on a reference being made. Full stop. In the instance case, however, it is seen that no reference was made, and the Labour Officer Dhemaji had assumed jurisdiction and passed the impugned order dated 17/7/2024. Full stop. While such action may not be accentuated by any malice or bias, there would be an apparent lack of jurisdiction on the part of the learned labor officer. Full stop. It is right that unless a person is authorized by law to do a certain thing, such action cannot be sustained in law. Full stop. In the instant case, there is a mechanism laid down in the Act of 1955 regarding redressal of dispute. Full stop. Para. This court is of the opinion that even without going into the inter se merits of the parties before this, in this list, the order passed, the labor officer, Dhemaji, did not have the jurisdiction to pass the impugned order.
dated 17/7/2024, and accordingly, the same is set aside. Full stop. This court is of the opinion that the argument raised by invoking raised in relation to Rule 36 of the rules of 1957 is not even required to be gone into in view of the findings already arrived at. Full stop. Para. While the impugned order is set aside, this court is of the opinion that the aggrieved parties would be at liberty to raise the dispute in the manner prescribed in law, and if the same is raised, the same is required to be brought to a logical conclusion by following the mandate of law. Full stop. Repetition accordingly stands allowed in the manner indicated above.
There are two expenses of section 12.
17, we said.
Of that.
Mm.
Of that.
Section 17, huh? ইয়াতে ওলাই দিবা হা মোৰ ইয়াতে মাৰি পেলাই মোৰ তাতে ওলাই দিবা Yes. Item number? Yes. এইটো কি হলে 2টা বজাত আছিল যে এইটো কৰি দিয়া Mr. Datta, we'll take up that matter, Mr. Goswami, just a minute. It's the old matter of 2017. What is your matter? Affidavits exchanged?
No, my lords.
Submit the instructions today.
Yes.
Whether the case I have.
Notice was issued. Notice was issued.
Order on this court, my lord. The case is similar. So
Is it similar?
Yes, my lords.
It can be covered.
Yes, my lords. Factual positions are very much.
Where is that order?
We haven't yet received instructions on this matter, however. But it does cover factually.
Now you have you got the instructions that it is covered?
My lords, no, but like.
No, your opinion will not be sacrosanct. You have to have the instructions.
Then
Law,
my
you can advise your client, but factually, have you verified the facts
Yes,
with
my
the
lords.
clients?
With the clients, not yet. We have sent them a communication.
Have their
regarding-
communication. Have it on Monday.
Okay, my lords.
Monday will. Okay. Because there does not appear to be a dispute with regard to the application of the law. Only we need a factual clarification. That's all. Okay.
Oblige, my lords.
Heard Sri B.D. Goswami, learned counsel for the petitioner. Para Sri S. Sharma.
Yes, my lords.
S. Sharma, learned counsel, appearing for the BTC, has fairly submitted.
Forest.
For the Forest Department has fairly submitted that the issue appears to be covered by an earlier judgment of this court. Full stop. He, however, seeks some time to obtain the instructions on the factual aspect. Para, be that as it may, and in the interest of justice, matter is adjourned to be listed on Monday next.
Oblige, my
To enable the learned counsel to have the instructions.
27.
Monday, 27th.
What's up there?
Oblige, my lords.
Item 1.
Yes.
In the pendency of the repeat process, subsequent claim has been already settled.
Now, what is the case we are going to dispose of? What are the basic facts?
Okay, oil limited ODR waste, okay. Purchase some annuity. Two claims are, we have, group personal accident insurance policies.
The petitioner is the All India Limited.
Has been claiming group personal accidents, policies is called as GPL, okay.
Group personnel accident.
Policies. Marine inland.
Inland,
And marine cargo. Paragraph 3, Lordship, paragraph 3 of the revision that
marine cargo.
cargo.
Okay.
From the insurance program or insurance Lordship, that is the respondent in this case, from since 2008,
From
2008, 9.
Mr. Doctor is R4.
Yes.
R4 insurance.
2, 3, and 2, 2.
Okay, what is the name of the which is number?
3 and 4.
No, 2, 3, and 4 are the
Oriental Insurance Company.
2. Oriented 2.
It's a
All three. Okay. The different
It's a
districts.
PSO.
Oh, no, 2, 3, and 4 are all oriental, different. Not required actually, but nonetheless, okay. 2, 3, and 4. Thereafter,
Thereafter, accordingly, Lordship, all loss is clean. And some are settled from 2016 onwards.
you claimed you had a claim.
Yes.
Some settled.
Some settled.
Then
Thereafter, annexer 4 of the resolution, we have go to the corporation.
page
Page 60.
60.
These are the pending claims, Lordship. Regarding the GPA claims.
This is a table of pending claims.
Pending claims regarding in respect of GPA. As on 22/11/2016.
Group personnel.
And in respect of marine claims, Lordship, pending as on 22/11/2000, page 61 to 69.
Yes,
61 to 69, Lordship, in respect of the marine claims.
correct.
Amounting to rupees 2 crores,
Marine is 2 crore about.
about 2 crore 98 lakhs.
And group personnel
1 crore 86,000.
1.8.
86 lakhs 72,000.
Okay, 1.86 lakh crore around approx. And marine
And 2 crores 98 lakhs. 32,200.
2.98 crore. Okay.
Thereafter, we wrote to the respondents also, page 65 onwards, there is a several communication.
Yes.
If Lordship use the page 73.
7.3.
Seven.
Yes.
Still, yes. By the respondent who was so close. This is the so close notice, Lordship, 24/11/2026. Maybe. You are hereby required to show cause in writing within 15 days from the receipt of the notice as to why there should not be a banning of business with your company, the Oriental Insurance Company Limited, and OICL be debarred from entering into insurance or any other contract with Oil India Limited, and be not delisted from the list of approved insurance companies with Oil India Limited due to non-settlement of outstanding insurance claim from the financial 2008-9 to financial 2015-16 lost by Oil your company, which is tables. Yes. It refers to this letter, this so-called notice, their response is page 78.
Yes.
So here, basic contents of page 79, some untraceable files will be reconstructed based on photocopies of documents which your good service agreed to provide. And accordingly, documents were provided, Lordship. And during the pendency of the requisition, since that time they have not acted upon, and therefore we have filed this requisition. And during pendency of the requisition, they have settled certain claims. Now, as on 7/2/2024, which is still here, Lordship, only this portion of unsettled claims.
These are the pending amount. Both for personal accident and marine. Both for my
Personally.
so one is 4,95,502 GPA, group personal accident. 4,95,502, correct?
Yes.
And marine is
28,83,921.
28,83,921. 3, 2, 4, 15, 9, 17, 1, 13. 33,79,000 total. So it is still pending.
Exactly on 14/2020.
When?
On 14/2016, Lordship. Because Learned Senior Fan has given a chart that some are documents are missing. Therefore, Lordship wrote this letter and thereby provided all the documents. List of claims. Because original already documents while lodging the claims, Lordship, they have already submitted the original documents.
That is your case?
Yes, sir. At the time of filing of the requisition, Lordship, our pending claim was paragraph 11 of the requisition.
How much was it?
Total, Lordship, 3,76,39,206.
Now 33 lakhs is there.
So that's why Lordship may direct the respondents to finalize the claim in a specific period.
Yes, Mr. Dutta.
Lord, my learned friend is very right in saying that within a time frame, the matters, possibly the insurance company can.
It has
settle.
come down to a substantial
Yes,
level. 3 crore was the claim now during dependency.
Right.
Maybe some documents were missing.
Yes.
But after reconstruction, a present claim is around 33 lakhs.
Right.
Which is still pending to be considered and for you to pass appropriate orders.
Yes.
You passed? What papers do you have? Anything new?
These are the
They
papers.
are also doing because on 5/12/2023, its claim was unsettled claim was around
Yes.
48 lakhs.
Right.
Because this on court monitored and accordingly the same was subsidiary to around 32 lakhs.
My Lord, in terms of the letter dated 7 February 2024, my Lord, the company informed me. Yes, sir. 13. My lord, your lordship can look at that. There are certain reasons why they could not complete it, but then even after that, I don't find any endeavor on their behalf. After that also possibly my learned friend furnished certain papers. 14.
Partial year of lordship, I have already placed the 42 letters. Then year of third lordship, I have already placed the 42 letter. Legal limited approves the respondent and accordingly submitted.
My lord, what I feel, if your lordship within a time frame, your lordship give a
Okay.
direction to
Yes,
the.
yes, yes, we'll do that.
WhatsApp will do that.
Please have your seat. Let us. The instant petition under Article 226 of the Constitution of India. Mr. Kolita, please have your seat. Has been filed by the Oil India Limited with the following relief, page 12, full stop. Bereft of details, comma, as per the facts projected, comma, the petitioner has been obtaining different insurance policies from the respondent numbers 2, 3, and 4 mainly pertaining to group personnel accident within bracket GPA, comma, marine inland and marine cargo, full stop. Such policies are being procured from the year 2008-2009, and accordingly, various claims were raised, full stop. Though part of the claims were settled, comma, a major part was not settled, and in this connection, the petitioner has projected the pending amounts both for GPA and marine in the form of tables amounting to rupees 1.686 crore approximately and rupees 2.98 crore respectively. Full stop. Though several communications were made, comma, no efforts were made by the aforesaid respondents to pay the amount, leading to issuance of a notice dated 24/11/2016 in the form of show cause as to why the said respondents should not be debarred from further business with the Oil India Limited. Full stop. The said move had culminated in an actual debarment, full stop. Nonetheless, the contesting respondents had furnished a response on 14/12/2016 that the files and papers would be reconstructed, full stop. However, as no further action was taken, comma, the writ petition was instituted, full stop. Para. I have heard Sri K. Kolita, learned counsel for the petitioner. I have also heard Sri S. Datta, learned senior counsel, assisted by Ashram for the contesting respond numbers 2, 3, and 4. Full stop. At the outset, comma, Sri Datta, the London Senior Counsel, has submitted that though affidavit in opposition has been filed on 4/9/2019, comma, in spite of repeated reminders to get the updated instructions, comma, no such instructions were forthcoming. Full stop. Forthcoming, and accordingly, he had prayed for some more time. Full stop. The said prayer, however, was declined by taking into primarily on the aspect that the writ petition is pending since the year 2017. Full stop. Para. Sri Kolita, the learned counsel for the petitioner, has fairly submitted that, as a matter of fact, during the pendency of the writ petition, comma, substantial number of claim has been settled and amounts paid. Full stop. He has submitted that towards GPA, comma, an amount of rupees 4,95,502, and for marine claims, comma, an amount of rupees 28,83,921 have been paid. Full stop. He has also submitted that subsequently also via a communication dated 14/2/2026, comma, the petitioner has furnished all available documents for settlement of the pending claims. Para. Sri Dr. the London Senior Counsel has submitted that the only reason of not being able to settle the policies was because of the fact that the relevant documents were not traceable. Full stop. He has submitted that all efforts were done by reconstructing the documents by taking aid from the petitioner, and as a matter of fact, comma, substantial amount has already been paid and the claims have been settled. Full stop. Para. It appears that while that at the time of filing of the writ petition, comma, the claim amount on both the heads were a substantial one, as mentioned above. Full stop. However, comma, as submitted, comma, during the pendency of the writ petition, comma, substantial amount has been paid, and presently a total amount of rupees 33,79,423 appears to have been pending. Full stop. Para. Considering the facts and circumstances, and also the aspect that the claims does not appear to and also the fact that there does not appear to be serious objections to the claim raised by the petitioner Oil India Limited, comma, the respondents numbers 2, 3, and 4 are directed to settle the remaining claims expeditiously and in any event within a period of 4 months from today. Full stop. The such settlement be done on the basis of the existing documents and in terms of the further copies of the documents which appears to have been provided by the petitioner via
letter dated 14/2/2026. Full stop. Writ petition accordingly stands disposed of.
Much obliged.
This is wrongly listed for order. Admission. No,
Award.
no, not award.
Then
A strike was resulted by registered trade union. And in consequence, where liquidated damage was, we have challenged that action
liquidated damage by whom?
by the management.
Liquidated damage under what provision?
Lordship, we deducted the amount from the contractor, Lordship. That's why we have taken the preliminary ground that contractor is not a party, Lordship. Because
Oh, you
in
are
term-
trying to extract from the workman.
Yes, no, Lordship. We have in terms of the contract, because the strike was resorted illegally, Lordship.
Now that is okay.
Ah.
The aspect of paying LD to the contractor. Now you're trying to take it out from the.
They have conciliation proceeding was initiated, Lordship. That was failed. Section 12(4)
It is
report
for
was-
orders because it is for the purpose of enabling you to file rejoinder, which you had prayed for time. Are you willing to file rejoinder affidavit?
Not solved by purpose.
Then we can have it for admission hearing. We can say.
Yes, that will be better.
Okay. Sri Dasgupta, the learned senior counsel for the.
Campus, the cases.
Yes, senior counsel for the petitioner has submitted that rejoinder affidavit may not be required. Full stop. Also heard Sri K. Kolita, learned counsel for the response number 2, 1 and 2. Full stop. List this case for admission hearing. When? Admission hearing.
Except 29, Lordship.
Uh,
28.
on 30th, 30, Thursday.
Here I have some problem.
Tell us the date of your convenience, Mr.
Before
Dasgupta.
30 or after.
6th August, Thursday.
Or it can be Tuesday also.
Which Tuesday? Next Tuesday, many matters fixed. 6th,
20,
Thursday.
20 we have case.
6th. Okay.
6th of August.
August. Thursday, we'll try to dispose of the matter.
Yes, sir, that will be
But
better.
we have to show, you have to show your power to.
But this.
Yes.
How do you extract LD from the workman?
No, Lordship. We have only from the contractor, Lordship.
You, whatever, they are not the contractor.
They-
Are you the contractor?
They
no.
at
You are the
their
affected
at
party.
their instance, Lordship, conciliation proceeding was initiated. That was failed. The appropriate government has
Whatever was the case. is,
rejected
basic
their claim to
question is
refer the
whether
dispute,
it is-
Lordship.
whether
You,
it
you
is-
seek damages against the
And
union.
accordingly, the
You
Lordship,
seek damage against the
Lordship, during the
union,
pendency-
file a civil suit for
during the
damage.
pendency of the writ petition,
How do you impose LD? How is it connected with LD?
but Lordship, during the pendency of the writ petition, MOS was also executed.
Let us see.
Anyway, let us 6th. that will be-
MOS under section 18 or what?
Yes,
Yes,
Lordship.
between
Yes,
18 and 19.
now,
18.
wherein specific clause that they will withdraw all the claims, Lordship, during the pendency of the writ petition.
Okay. Interesting.
Item 21.
IA 4? IA, you had short time. There's some succession was going on.
Going on.
Now it's over or not?
No, no, not yet.
Not
It is
yet.
fixed on 3rd of August for necessary order.
We know that succession is gone.
Yes.
Okay. Heard Miss R. Devi, Leonard CGC, as well as Miss Peter Lugdar. Peter Lugdar, Leonard counsel for the opposite party. Full stop. Para. Miss, both the, you are also there in the succession matter. No, you are not there. So, Miss Talukdar, the Leonard counsel has submitted that the succession matter is yet to be over, and the next date is on fixed on 3rd of August. Para. In view of the above, matter is adjourned to be listed after 2 months. Yes, madam, you are for whom? AG, you are a party here. Okay. Yes, you give your name on behalf of your name. A. Sharma on behalf of B. Chakraborty.
Standing Counsel AG is present.